where it stops, no one knows. We're going head into the unknown. Na, 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 na.
All right, then this would be an appropriate time for us to break for lunch. If you would report back to the courtroom by 1 o'clock, the courtroom will be locked and everybody needs to vacate and take your materials with you.
Judge, I had a question.
We're not done yet, folks. We're still on the record. Have a seat.
You have a what?
A question unrelated to this. I had received an order that a motion to dismiss will be heard today. Is that still the case?
That was still my intent.
Okay, that's all I wanted to know. Thank you.
All right, be back at 1, please.
All rise.
Thank you. You may be seated. Okay.
No talking in the gallery at all. None.
All right, we are back on the record. Mr. Hennessy, are you ready to proceed?
Yes, Judge. First, I would make a motion pursuant to Trial Rule 41B. At the close of all the state's evidence, I would remind the court that the proof has to establish willful and intentional disobedience. The standard is beyond a reasonable doubt, and that comes from a 1927 case that has never been overruled, and I will quote from that. I just had it. I'm sorry. Okay. It's the case of State versus Schumacher, 200 Indiana, IND, Supreme Court, 623-704 at dash 704 to 706. 158 ND NE 2D 69 at 791. The chief parts are it's a criminal contempt case. The case is governed by the analogies of criminal procedure, and the respond is entitled to the same rules of evidence. The presumption of innocence that avail him in any criminal case. The evidence must be sufficient to establish guilt beyond a reasonable doubt. I want to start with Mr. Rozzi, because there's truly little, if any, evidence of him at all. If you look at it, he wasn't involved in the Westerman leak. That wasn't his office. The Woodhouse thing, he wasn't involved in. There's no evidence that he was. There's no evidence connecting him to Westerman, and there's no evidence that he lacked any candor towards the tribunal. Now, that leaves you with the press conference, and clearly both Mr. Rozzi and Mr. Baldwin did the press release, but it's a day before the court order, so that can't be contempt. So I asked for a finding of no contempt for Mr. Rozzi at that time.
Well, sir, we had states exhibits 1 through 10 that have been admitted, some without objection, some over objection. I have not reviewed any of those exhibits and am unable to rule on a 41B motion without having reviewed the evidence that has been presented. So I'll have to take your request under advisement.
Okay. Then moving on to Mr. Baldwin.
I would have the same response to your argument, sir. I have not reviewed states exhibits 1 through 10 as relates to any of the information, and I
just want to...
If I could finish, please. Stop interrupting me.
Oh, I'm sorry.
I cannot make a ruling on your 41B without having reviewed the evidence. So I will take the evidence and your request as it relates to Mr. Baldwin as well under advisement.
I just wanted to make my argument so you'd have it when you do review the evidence.
That's not necessary. I know what your argument would be, sir.
Okay. I would call Mr. John Boren to testify. Attorney Witnesses takes the stand. Please state and spell your name.
John D. Boren, Boren,
What do you do?
I'm an attorney.
And how long have you done that?
In October, it will be 47 years.
So you were admitted in October of 1977?
That is correct.
Where'd you go to law school?
I went to law school in Oklahoma for the first year, and then I transferred back to Indiana, which was a lot cheaper as a resident than I went to McKinney. Back then, it was just Indiana University.
What was your practice after admission?
Initially, after being admitted, I was a deputy prosecutor for G. Thomas Gray down in Morgan County for approximately 14 months. At the end of the 14 months, January, excuse me, of 1979, I opened a practice in a little office above Folly and Peden in downtown Martinsville, and I practiced there for 2 years. After those 2 years, Steve Oliver and I formed a partnership called Boren, Oliver, and no, it was just Boren and Oliver initially.
Have you tried both court trials and jury trials?
I have.
How many, approximately, jury trials?
Approximately 100 jury trials and too many court trials. I couldn't count them.
And have you done trial preparation in regard to those trials?
I have done trial preparation. Actually, I started trying jury trials when I was an intern. Back then, it was pretty loose, and as my senior year or last year of law school, I tried 2 jury trials. One was a kidnap, and the other one was a major felony case. So I've been doing jury prep ever since I started. And when I went into private practice, I paid for myself to go down to the National College of Criminal Defense Lawyers, and I met, as I now know, people don't recognize these names, but they were icons at the time: Bobby Lee Cook from Valdosta, Georgia, Racehorse Haynes from Texas, and Garvin Isaacs, who was from Oklahoma. And they taught us a lot about jury prep.
And with regard to consulting with other attorneys, is that normal and expected?
It is. I obviously still do it today. I think maybe I should tell you that I'm of counsel of the law firm Boren, Oliver, and Coffey now. So I've got one foot out the door trying to clean up all my cases and get out.
And how about consulting with non-lawyers?
I think it's more important to consult with non-lawyers than with lawyers, though obviously lawyers can give you some tips in regards to the law. But I've only, in 47 years of trying jury trials, I've only had one jury trial in which I had a lawyer on the jury. So it's really important, in my opinion, to consult with non-lawyers.
And in doing that, so you get a better perspective of what? How your jury will react to the evidence?
Absolutely.
So in doing that, do you share with them the discovery and what you've learned and what you expect the evidence to be?
Absolutely. One of the things that I really felt like I had a good handle on was doing what we call mock juries. And for probably about 4 or 5 years, myself and Nina Miller, as part of the public defender group in Indianapolis, conducted the seminars. And Nina was a psychologist, and we taught prospective litigants how to assemble juries, how to interview jurors afterwards, and the evidence that you have. You want to see what's going to suck the air out of the room or what's going to be benign. But some things that we as lawyers think are real important, mock jurors will tell you they're not important at all.
And then the consultation with both lawyers and non-lawyers, is that something criminal defense lawyers refer to as brainstorming?
Absolutely. And there's probably another element to brainstorming. Saturday mornings, this is what I'm going to miss when I retire completely. But we would sit around and brainstorm our cases and, talk about the facts and look at the evidence that we had been produced.
Have you attended continuing legal education seminars where brainstorming was discussed, recommended, and taught?
Yes. I've been a presenter at least three different occasions in which we roundtabled, and this was for medical malpractice. I did about a 50-50 practice in my 47 years. 50% was civil, 50% was criminal. But one of the seminars that we did was very much a brainstorming. And we would have a group of people that were attending our seminars, and we would do our brainstorming and talk about it.
And then are you familiar with the term war room in terms of trial preparation for criminal defense lawyers?
Absolutely.
Please tell the judge what that is.
Well, that's where critiquing our case that you present to, whether it be lay personnel or whether it be attorneys, you get an idea of how your presentation is coming across. And people, hopefully you have good people that will tell you the truth, like that this is working and this is not.
But with regard to trial preparation for a major trial, would you have all the evidence set out in a particular area as you approach trial?
Absolutely. We, in my practice, which is in Martinsville, Indiana, we have 2 conference rooms. And we had a big conference room that frequently we have had pieces of evidence such as photographs, diagrams, as technology began to increase, we would have, cell phone analysis. All of that would be out in our either whichever room we decided to use. And frequently I would have to put that in my office as well.
And have you ever sent an accidentally misdirected email?
I have both been sent accidentally, and I'm not real computer literate. And I received email that is not intended for me and sent to someone that was not intended.
What would you do once you realize you sent it to the wrong person?
Once I sent it to the wrong person, I would try to communicate to that person that it wasn't intended for them, and would they please delete it? And depending on the magnitude of whatever I'd sent, I might ask them, don't disclose this to anybody.
And if you received a misdirected email, what would you do?
When I realized it was misdirected, I would stop immediately, call the person, delete the email, and tell the person that it sent it to me that I deleted it.
Having taken such corrective actions with either one, would it cross your mind, or would you feel obliged to report that to a prosecutor or a judge?
I guess it would depend upon what it was, I would probably, I don't know that I don't know why I would, report that to either the prosecutor or the judge.
You would figure it was cured, correct?
Right.
Okay. Why are you here?
Well, I'm here because I'm getting old, and I have experience, and I do not have training. And you indicated to me that maybe that might be something that the judge would like to know about.
Thank you. Nothing further.
Mr. McQuillan?
Thank you, Judge. Mr. Boren, good afternoon.
Good afternoon.
In your vast experience, which I appreciate, have you ever been subject to a gag order put down from a court?
I have not been subject to a gag order in my 47 years. And I handled the Steve and Judy case. That was before you were born, I'm quite sure.
Sure.
He and I didn't get along well, so I was relieved that I didn't continue that representation. But I have never received a gag order. In civil practice, I've received non-disclosure forms that we filled out.
Are you familiar with the gag order in this case? Have you read over it?
I think I have. My knowledge about this case is probably narrow. I'm sure many people sitting in the gallery know more about the case than I have. But I do believe I've read what that gag order in February of 2022, maybe?
No. This was on December 2nd of 2022.
I think I've read that one as well.
If I were to present to you that the gag order prevented parties from disseminating information to the public, that would coincide with your knowledge of gag orders. Is that a fair statement?
Right. The gag order can be tailored in whatever way the judge chooses to tailor it.
And if you had a gag order that were in place and you were to consult with a civilian, what precaution would you take to ensure that that civilian doesn't disseminate information to the public?
I might make a major mistake and think that my civilian would not disclose anything like that. I think that would probably be my nature. I've never had an onerous gag order. That's probably the best way I can answer your question.
Have you been subject to, and I think you've answered this, have you been subject to a protective order in terms of a discovery in a case?
Protective orders in civil cases, yes, I have. I've never been, let's put it this way. I'm an old man and my memory is not that great, but for over 47 years, I don't remember ever receiving anything like that. And even though Morton County's kind of a small place, but we've had some pretty notorious cases and I've handled most of them.
The protective orders that you've had in civil cases, have you ever violated those?
No, I've had one violated that impacted our case, but
Sure.
not me.
If you had a protective order and you did violate it, would you feel obligated to notify the court?
Certainly, if I realized I had violated it, yeah, I would tell the court.
What precautions, when you've had a protective order for discovery, what precautions do you put in place to ensure that civilian consultants that you have don't disseminate that information that's protected?
I've never had the occasion where I had to sit down and tell. I mean, most of my consultants were experts who were professionals in their field, and I've never had a reason to do that. Maybe that's negligent on my part, but I've never had to do that.
When you speak of the war room, would you put any precautions in place to keep the public from entering that war room?
Interestingly enough, I consulted with my partner, Mr. Oliver, and like I said, he's been practicing 45 years, and we've never put a lock on any door. We've never, put up a sign. It's just never something that's crossed my mind.
Have you ever been involved in a murder case where there were crime scene photos?
Oh, yes.
And have you ever released those photos to the public?
No. In the Stephen Judy case, I remember Tom Gray handing me, here's your copy of these horrific crime scene photographs. And do I remember I shared them with a lady next? I was practicing. I was out of the prosecutor's office, and I remember showing them to the lady next door and asking her what her impressions were.
Did you ever show those crime scene photos to one of your friends who was not let me clarify that, who was not a lawyer?
Yes, I'm sure I did, yes.
Okay. And your testimony is that you wouldn't put any safety precautions in place to ensure that those photos didn't get disseminated to the public if you were to show them to a non-lawyer consultant?
Well, now are you assuming that there's an order telling me that I have to do that or that I've got to take precautions?
Sure, let's assume that. Let's assume you're bound by a protective order. Is there anything you would put in place to protect those pictures from being leaked or disseminated to the public?
Objection, Judge. Mr. Boren, asked for clarification if there was an order to secure his war room so that Mr. McClellan switched that around to whether there's a protective order. So it's an assumption. It's not the question whether the court ordered that war rooms be secure is an assumption. That's not in this case because there was no such order.
Sustained.
Have you ever lied to the court?
Have I?
Yes.
Certainly not knowingly. I've never lied.
Sure.
Because the definition of lie is that you lie.
You have a professional liability as an officer of the court to be honest with the court. Is that a fair statement?
Yeah, I have a real aversion to the disciplinary commission.
And I agree. Have you ever told the court one thing and then done the complete opposite?
I certainly don't recall ever doing that.
Okay.
I would say this, I'm certainly capable of forgetting things, and my staff tells me
Sure.
I'm even worse now than before.
Sure, understand. Thank you, Mr. Boren. I have no other questions, Judge.
Mr. Hennessy?
No redirect, thank you.
All right. Thank you, sir. You may step down.
May he be excused.
I
Yes, from the state's perspective, Judge, I don't intend to recall him.
Okay. Thank you, Mr. Boren.
You may call your next witness.
We're going to call Kay Beehler. Please state and spell your name.
Kay Beehler. My last name is Beehler.
What do you do?
I'm a lawyer.
What kind of area of law?
I'm a criminal defense lawyer.
Did you start in Indianapolis?
I did.
You start as a prosecutor.
I did.
Did you do
For about 3 years,
did you do criminal defense work in Indianapolis?
I did.
And then where did you go?
I was in Indianapolis with the Public Defender Agency until 2004. And in March of 2004, I made my way to the state of Maryland and worked in their Capital Defense Division doing death penalty defense only.
And have you retired from that position?
I've tried, yes. I'm not very good at it.
Are you back in Indianapolis?
I am back in Indiana. I'm in Vigo County right now. I specialize in appeals.
So you've had both court trials and jury trials.
Yes.
And you've done trial preparation for both court trials and jury trials.
Yes.
Please describe your trial preparation for the court.
I have interviewed witnesses. I've gone to the scene. I have looked at, examined, and photographed every piece of physical evidence in a case. We've made whiteboards, files, particularly in capital cases. We would have a room, an absolute conference room full of the file tubs in capital cases. It was discovery. I've brainstormed with other lawyers. I've developed a theme of my case and tried to prepare my presentation around that theme.
Have you brainstormed with non-lawyers?
Oh, yes, absolutely.
In doing both, would you reveal the evidence so you could get their true reactions to it that you might find at a trial?
Of course.
Have you attended continuing legal education seminars where brainstorming was discussed and taught?
Absolutely. Yes, many sessions on brainstorming, and particularly sessions on how to get your point across, how to put your case in front of a jury.
And would you share sensitive or graphic evidence with non-lawyers to ascertain their reaction?
On occasion, it would be a case specific. It would be case specific, but yes, it absolutely happens.
Have you ever accidentally misdirected an email?
Oh, yes.
How many times?
Oh, once or twice.
Have you ever received a misdirected email?
I have.
What would you do when you sent one?
When I sent one, depending on to whom and what the subject was, I would normally either pick up the phone or send a quick email back and say, disregard, irrelevant, not for you. Or I'd pick up the phone and say, just delete that, please.
Did I ask what you would do when you received one?
When I received it, knowing it wasn't for me, I just scrolled on by. I just deleted it. Wrong guy, wrong person.
Once you've taken the curative action, would you see any need to report it to a prosecutor?
No.
Or a judge?
No.
Do you know Mr. Baldwin or Mr. Rozzi?
I do not. Only in the publicity surrounding this case.
Thank you.
Mr. McClellan?
Thank you, Judge. Ms. Beehler, have you ever been subject to what we refer to as a gag order in a case?
Yes, I've gotten them before. I've asked for them.
Okay, and have you ever been subject to a protective order for discovery?
Yes, I'm under one right now in a federal court.
With the gag order specifically, if you violated the gag order, even inadvertently, would that be something you'd notify the court of?
I'm not sure specifically.
If you disseminated information in violation of the gag order, even if it was an accident, would you notify the court that you had done so?
Probably at the next opportunity, depending on what it was.
If you
I would note.
Disseminated evidence or at least witness names and discovery in a case, would you notify the court if it was a violation of a gag order?
No.
Okay. And you said you were subject to protection order. When you would show or converse with non-lawyers, would there be anything you would put in place to protect the evidence so that you would comply with the protection order?
There is a way, a mechanism to brainstorm a case and not violate a gag order. It's done all the time.
Sure. Have you ever released crime scene photos to the public?
No.
And have you ever lied to the court?
Have I ever what?
Have you ever lied to a court?
No.
I don't have any other questions, Judge.
No redirect.
All right. Thank you, ma'am. You may step down.
I call Andrew Maternowski. Please state and spell your name.
First name is Andrew. Middle name initial C as in Charles. Last name is Maternowski. Maternowski.
Are you a criminal defense lawyer?
Yes, I am.
How long?
I'm in my 35th year.
And where did you go to law school?
I went to IU Indy.
And what was your practice after? Oh, when did you get admitted?
1989, fall of 89.
And what was your practice after that?
When I was in law school, I did a certified legal externship, I guess, is what you'd call it, with the Marion County Public Defender Agency. At least at that time, during my summer job, I was also working for a private attorney in Indianapolis doing criminal defense. When I finished school, I think the day I got sworn in, I did a hearing that afternoon in Marion County and have spent 17 years working with that attorney, doing almost nothing but criminal defense. Then I moved out of his building into another building for 10 years, doing almost nothing but criminal defense. And then I moved back to the original building 6 or 7 years ago. So it's always been primarily criminal defense.
Approximately how many court trials and jury trials have you had?
Court trials, I have no idea. Jury trials, 35 to 50. I've never kept track of numbers like that or caseload or anything like that.
How many different jurisdictions?
I've practiced throughout the state of Indiana. We have 92 counties. I think I've counted up. I've practiced in over 80 of them, probably juries in 20, 15 to 20, maybe 25 different counties. I've done stuff in federal court in the Northern District of Indiana, Southern District of Indiana. I think it's the Eastern District of Tennessee, a jury trial, and then a jury trial in Missouri, and jury trial in, not a jury trial, a criminal case in San Antonio, Texas, in federal court.
And in your trial preparation, would you consult with both attorneys and non-attorneys?
Yes.
And would you share with them the expected evidence
I would.
for those trials?
I would.
Why do you do that?
To get a better perspective. I found that when I'm preparing for a trial, because I'm looking in my client's best perspective on how are we going to try this case and win this case. The term I've used is breathing your own fumes. When you think you have a great theory of a case, theme, a great approach to how you're going to defend the case, and then you call your older sisters and they tell you that, I can't use the term my sister used, but you're on the wrong track.
You've heard me discuss with other attorneys about a war room.
Yes, sir.
What's your definition of a war room?
Essentially, a conference room where everything is spread out. A lot of younger attorneys can do everything on phone or an iPad or a tablet or a laptop. I can't. I have to have printed pieces of paper spread out everywhere. When I start prepping my case, I make copies of almost everything. And then I made a copy with color-coded pens where I do all my notes, and I need a copy of that to be able to pick up and look and hold, and then I pick up another piece of paper and look at it and hold and say, okay, here's what attorney A said. Here's what attorney B said. I can't do that on a computer. So what I do is we have a conference room on the 3rd floor and a conference room on the 1st floor. I'm in an old house on the north side of Indianapolis, and there's a big table on the 3rd floor and there's a big table on the 1st floor. And I would spread things out all over both those tables, depending on which one I start using first.
Have you ever received a misdirected email?
I have. I received many over the course of my time, one from a prosecutor when he and I were discussing a deposition. And when I received it, I sent it back to the prosecutor and said, this was not meant for me.
Was it apparent from the email that he was intending to send that to a police officer?
Yes. We were in the middle of talking about a suppression issue and trying to schedule a deposition. And the email that was sent to the police officer or sent intended to go to the police officer, but actually went to me, indicated that, referring to me, that I apparently figured it out, what the suppression issue was. And I told the prosecutor that I received that email, and within a couple of days, I think the case was dismissed.
Have you attended CLEs where brainstorming was addressed or taught?
I've both attended and taught at seminars.
Tell us a little bit about your teaching.
Okay, for 22 years, I've been on the faculty of the Trial Practice Institute. It's an annual program put on by the State Public Defender Council, where we break down cases into small groups, and you start with brainstorming, and you start with, then move onto into voir dire techniques and direct exam, cross exam, opening statements, closings, and you essentially, when you're in the brainstorming part of the case, we used to work from a set fact pattern. There's a fact case out there where there's some allegations against the person at 2 different crime scenes, and everybody worked from the same fact pattern. About 15 years ago, we shifted to a bring your own case format where every participant, these are public defenders and private defense counsels from throughout the state, would bring their discovery and bring their cases with them. We found it more helpful to do real facts and real cases that people were really going to be trying in the future.
And you've described your war room as being separate from your private office.
Yes.
And would you expect to be betrayed by a friend or a former associate that comes to visit you in your private office, but unknown to you, goes into your war room and takes pictures of the stuff in it?
I would not.
Would you feel any need to put up protections against such a thing?
No.
You would not anticipate such a thing happening?
Oh, the location where the war room would be set up and everything would be spread out would not be in a location where I would expect anybody.
Well, from the general public, but if they were a friend or a former associate and had come to where your office is and found you unavailable, would they be passing like the 1st floor war room?
In order to get to where my separate office is, they would go alongside where that war room is.
So they could go in there and take pictures without your knowledge.
Yes.
And you would not expect, you would have suffered such a betrayal?
I would not.
That's all I have.
Mr. McQuillan?
Can you say your last name for me one more time? I apologize.
Maternowski.
Maternowski, Kay. It's a lot simpler than people oh, that's you.
It's a lot simpler than people try to make it.
Thank you, sir. Good afternoon.
Good afternoon.
I want to talk about some emails first. Well, let's back up. Have you ever been subject to a gag order
I have.
in a case? And have you ever been subject to a protective order?
Yes.
And you had talked about if you inadvertently send an email to somebody, if you inadvertently send an email to a civilian in a violation of a gag order,
Judge, I'm going to eject. Assumes facts not in evidence. A misdirected email was not a violation of the gag order. That's a legal conclusion for this court to make. Now, if he wants to say, like, ask the question, did you ever send an accidentally misdirected email that had an outline of your discovery organization? That would fit the evidence so far.
Would you like to finish your question before I rule on his objection?
Sure. Judge. I'd like to respond to the objection too, but let me see if I can phrase it the same way, Judge. If you send an email to a civilian in violation of a gag order, is that something that you would feel that you need to make the court? Do we need help? Do we need to call for help?
Is everything okay?
He's yelling at his Xbox and his friends on his Xbox.
Oh, okay.
Oh, yeah.
Sorry. And he's on a whole nother floor. Sorry.
Oh,
I have
my
one of those.
word.
It's totally okay. I get it.
He's 12. I don't know.
That's just how it goes. I have one that does that.
When they're like super far away, it's hard to tell if it's like, oh, I have a really funny story I'll say for later about, has anybody ever heard a sheep? A sound that like a sheep makes?
Mm-hmm.
Yeah.
So what about a goat?
Mm-hmm.
Yeah.
Okay. So like one time I called 911 because I thought someone was being murdered.
Because there was
I was
a
going, help! Help! And I was like, are you okay? And it just kept saying, help! And I called the police. I'm dead ass serious.
Oh my.
All right. If you've ever heard them, I had never heard a goat before that time. Okay. So if you had sent an email to a civilian in violation of a gag order, is that something that you would feel that you need to make the court aware of?
It would depend on who that civilian was. If I just sent it to somebody random, yeah. I probably have 5,000 people in my contact list. If I misclicked on something and I went to somebody, I would probably notify them immediately and say, that wasn't for you. Don't do anything with that. Because I don't know what they did with it. I don't know that I'd have a reason to notify the court. I didn't intentionally violate it.
And so let me make sure I got this correct. So if you sent an email that violated a gag order that was in place in your case, meaning that email would have to have some information pertaining to the case or evidence pertaining to the case, you wouldn't feel it necessary to notify the court that even inadvertently, if it was inadvertently, that you had done that?
I wouldn't notify the court at first. I'd probably notify, in a typical case for me, it would be the prosecutor. I would say to the prosecutor, hey, this is what happened. What do you want me to do?
Okay, fair enough.
If they said we need to tell the judge, we'd tell the judge.
Fair enough. You had talked about oftentimes, maybe not oftentimes. There's been times that you've had cases and you've run the information by your sisters or sister to get their take on the presentation of your case.
Yes.
Is that
Okay,
go ahead.
I've got a D felony or a level 6 jury of older sisters. I've got 7 older, scroll up, sisters, and they're all semi-professionals and they've got a lot of experience. I've got one sister who's a retired nurse who I trust her opinion on medical things more than any doctors, that I've looked at autopsy photos, injuries, things like that.
And is that for you to be able to get someone from the public, their opinion on the strengths or weaknesses of your case?
With that particular sister, no. That's usually for more of an expert opinion, but I've done similar things with other people, other civilians, other family members, other attorneys, friends.
And again, is that to determine the strength and weaknesses of your case as they see it?
Yes.
Okay. And so is it fair to say that with the evolution of the internet and the evolution of social media, that an attorney could also use social media and the internet as a way to push out the facts of their case to gauge the public response?
You could, yes.
Okay.
I'm not sure how useful that would be if you're not getting any feedback.
I don't have any other questions, Judge. Thank you.
No redirect. Thank you.
All right. Thank you.
May he be excused?
Thank you, sir. You may step down.
And can Miss Beehler be excused?
I have no objection, Judge.
Yeah, that's fine. You may call your next witness.
Judge, at this time, I would like to have an affidavit of Thomas Leatherman marked as Exhibit B. You have all these, right?
Yes. Are you going to attempt to admit all the affidavits that you gave me?
Yeah.
Okay. Judge, I just want to show a running objection to those. Without the witnesses here to testify, I don't think it's fair to the state. We don't have an opportunity to cross-examine them or question them about the information in the affidavit. And so if this court would just show my objection to those exhibits being submitted to the court.
I'll show a continuing objection. I'm sorry, what was D?
D was from Thomas Leatherman. C is Stacy Uliana. E, F is Amy Schultz. G is David Pumphrey. H is James Fry. I is Lisa Johnson. J is Joel Winnicky. And K is Gotchko Kasich.
Who?
Gotchko Kasich. He's Lake County. It's GOJKOKASICH. And I would call.
Okay, excuse me. So are you moving the admission of D through K?
Yes, ma'am.
And the state is objecting. And your grounds again, sir?
Judge, the state's objection is based on the fact that these are affidavits. The state doesn't have an opportunity to cross-examine these witnesses in order to check the veracity of the statements made in the affidavit and to question them about those statements.
Any response to the objection?
No, ma'am.
Then I will show D through K not admitted. You may call your next witness.
Julie Melvin.
What a
Please
bunch
state
of
and spell your name.
Julie, 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 Melvin, Melvin.
Do you know a Terry Williams?
Yes.
What?
Yes.
How do you know her?
I met her through this case.
I'm going to hand you what's marked as Defendant's L and ask you if you can identify it.
Yes.
What is it?
That is my phone record of phone calls that we had back in 2017.
With Terry Williams?
Yes.
And then, move to admit L.
Judge, I'm going to object. I don't know what the relevance to this exhibit is. Phone records between Julie Melvin and a Terry Williams. I'm not sure the relevance to this proceeding, Judge, so the state objects.
How's it relevant?
Well, the next sheet is a Facebook page, a shot of a Facebook page of Terry Williams. And it involves Terry Williams sharing with Miss Melvin confidential information about the investigation and from whom she received it. These are the other leaks, and the relevance again is to show that there's plenty of other sources not connected to. I mean, I'll tell you, I don't think the Westerman leak. Westerman's been connected to Andy by the evidence, but no knowledge of the leak. And so I'm asking to put in evidence of other leaks so that on the issue of contempt, A, that there's many other sources of information about the investigation. As the evidence goes on, there will be testimony that even of the photos they attribute to Mr. Westerman cannot have come from Mr. Baldwin's office.
And do you have this Terry Williams here to testify?
No.
Oh, well, then I'd have to sustain the objection.
Okay. Show L offered, please.
I'm sorry?
You're showing L as offered. It's in the record, correct?
It's marked, yes. And
okay.
You should give it to Jody.
Very good. Can you identify then what Exhibit M is?
That's you, Julie. You're muted, Julie.
Sorry about that. Yes, I can.
And what is it?
It's basically the accounting that Terry Williams gave to me on the phone, but it's written as she told it.
Was that a Facebook post?
Yes, by Terry.
Offer M.
Judge, I object on hearsay and also relevance. I guess I'm not sure of Mr. Hennessy's plan, but if his plan is to parade a bunch of podcasters and YouTubers up to the stand and talk about other leaks, that has no relevance in what we're here to discuss today, Judge. We're here to discuss the information the state outlined in the contemptuous information filed with the court. The fact that the defense, believes there are other leaks, or podcasters believe there are other leaks, or YouTubers believe there are other leaks, has no relevance to what we're here to discuss today, Judge. And so, on those two objections, the state is objecting to the admission of those pieces of evidence.
Well, number one. Oh, I'm sorry.
Go ahead.
Number one, it won't be a parade because I'm going to call them one at a time. Number two, it's highly relevant, and at least in my mind, it goes to the theory of the defense. Oh, and I already explained why it's relevant to both the punishment and contempt.
Okay.
I think at some point, if you get the question of punishment, if you get to the question of punishment, organizational math, and what kind of damage or prejudice or harm has that caused versus leaks about the complete probable cause affidavit, the existence of a bullet at the crime scene, the recovery of the firearm at Mr. Allen's house, and it goes on and on.
All right. I'll sustain the objection to M.
Have you followed the Delphi case?
Pardon?
Have you followed the Delphi case?
Yes.
Did you grow up in Delphi?
No.
What county do you live in now?
I live in Hamilton County.
Have you seen postings of other evidence from the investigation?
Objection, Judge. Again, relevance. I don't know what this has to do with the allegations outlined in the state's information.
Well, if he can't understand it, doesn't mean it's not admissible.
Well, you're in trouble now.
That's uncalled for, sir. And
I'm sorry?
that is uncalled for. Evidence has to be relevant to be admissible, and this is not admissible evidence. It's not relevant. I'll sustain the objection.
Okay, I'd make an offer to prove then. I can, and I'll approach with both the case law and the rule if the court would like to have it. I can do that by question answer, or I can do it in a summary fashion.
Summary fashion. I'm familiar with the case law and the rules, sir.
Okay. Miss Melvin would testify that she has followed this closely, that she has seen many other posts that has been publicly disseminated on purpose and willfully by other people that is evidence from the investigation, including crime scene photos unconnected to the defense, unconnected to Mr. Westerman, unconnected to Mr. Fortson, and that the sources have been vast, including law enforcement, Sergeant Holeman for one, and other people involved in the investigation. Thank you.
And if any of that had to do with the charges that are being alleged by the state of Indiana, it would be relevant. Do you have any further questions of this witness?
No, ma'am.
Do you have any cross-exam?
No, Your Honor.
Thank you, ma'am. You may step down.
I will call Stephen Wood, aka Skip. Please state and spell your name. And Skip, you're muted. There you go.
There we go. Oh, it's Stephen Wood. STEVENWOOD.
Do you have a nickname?
Online, yeah, Skip Jansen.
People call you Skip.
They do.
And have you followed the Delphi investigation?
I have. I followed it since August of 2020.
Do you know a Gary Boudette?
Yes.
How do you know him?
He and I became friends. We initially met around, I think, January of 2022. I made several appearances on his channel, YouTube channel, talking about the case, and we just became friends over that time.
And were you a part of a group that he was a part of a group of?
I'm sorry, what? Say it again?
Were you a part of a group that he was a part of?
Yes, we were in a Discord group.
Do you know of different names that he went by?
He went by Fig Saws. he went by Fig Newton USA, I think on Reddit, but mostly, he's known as Fig.
And Fig?
Mm-hmm.
Is that one? Yes?
Fig Sauls, Fig Newton.
And I'm going to hand you what's been marked as Defendant's Exhibit N and ask you if you can identify it.
Yes, this is a conversation he and I had over text.
And how do you know that?
I'm familiar with the conversation. He and I talked a lot. Like I said, we were good friends, so we communicated a lot.
Offer N.
Judge, may I ask a few foundational questions?
Yes.
Mr. Wood, the conversation that you had with Mr. Bodette, does it have anything to do about an email sent from Mr. Baldwin to Mr. Woodhouse?
It does not.
Does it have anything to do with photos that were taken from Mr. Baldwin's office?
I don't believe so.
Does it have anything to do with a press release from the defense that was released in December of 2022?
I can't recall.
Does it have anything to do with an ongoing leak from the defense out to the public?
From the defense, we talked about ongoing leaks.
I meant this conversation here that you're trying to admit.
Oh, no.
Judge, then I object to the relevance of this. I was going to say relevance of this hearing, which would have been appropriate, but relevance to this hearing. Could you imagine if he was like, I object to the relevance of this entire
hearing. This court is out of order. This whole court is out of order.
Whoopsie.
Any response?
No, I won't rehash.
Okay, then I will show N is not admitted.
Hand you Defense Exhibit O. Can you identify that?
Yeah, this is this is a text conversation between Fig, Gary Bodette, and myself, and it's covering several different things about the case, about sources in the case mainly.
Thank you. Offer. Nikki.
I guess I need to. Can I take a look at that, please? See what it is. Judge, same objection as before. The relevance to what we're here to discuss today in court. So just same objection.
Any response?
Same response.
And I will show O is not admitted.
I'm going to hand you an envelope marked flash drive Fig, November 22nd, 2022 YouTube video. Are you familiar with that?
I'm familiar with the video, yes.
And inside is a flash drive of that YouTube, and you recognize that?
I do.
And what does he talk? Oops. What about in that YouTube?
He talks about cartridges, bullets, casings, unspent casings, cartridges, mostly evidentiary stuff for the most part.
Move to offer Q.
Q?
Judge, I'm going to object. Same objection. Relevance. I don't know what it has to do with the information outlined in the state's filing.
Same response.
All right. I'll show Q is not admitted.
And then did Mr. Bodette reveal a lot of detailed information about the investigation?
Objection, Judge. Same objection. I'm not sure that's relevant to what we're here to discuss here today.
Sustained.
It's the same relevance. It's the same. My theory and theme regarding contempt and punishment, there's two parts to it.
You need to give that exhibit to Jody if you want it in the record, sir.
She has it.
Oh, you've got it? Okay. Do you have any further questions for this witness?
Offer to prove?
Go ahead.
I'd like to do it in question and answer form. It'll be brief. That's the preference under the rule.
You may proceed.
Could you please, just for the record, indicate what kind of information Bodette was putting out there?
Are you specifically to the October, November of 2022, or just in general?
All over.
A lot of stuff, so he claimed to have different sources and he talked about a lot of things.
Wouldn't he indicate that there was going to be a release of documents in 1 week, and then that occurred in 1 week?
Yeah, he did. I believe on June 16th of 2023, he said that his source had told him that they were going to release a large set of documents. Some are older, some new is how he described it. And then a week or so later, they were released.
Did he post that? He had the unredacted probable cause affidavit filed in support of the charges against Mr. Allen?
Yes.
And was that before it was publicly available?
I don't recall exactly. I do recall that he was adamant about the fact that the PCA had two versions. There was a 1.0 and a 2.0. And what we've seen, the public seen, was a 2.0 version. And that was, again, from the same source that told him about the documents that were released in June.
And did he claim that his source was an employee of Judge Gull?
He did.
Did he ever identify that person?
He did not.
Did he attribute other leaked information to that same source?
Yes.
And what was it?
He said that one was more of an opinion based. One said that this person thought that Richard Allen was guilty and hoped that Judge Gull kept him in Westville for a long time. Like I said, it was the PCA 2.0 version of that. The documents that were released in June, there was no reason to believe he wasn't telling the truth because everything he was saying was right.
Judge, I'm going to object at this point. I think we've gone beyond an offer to prove. We're into speculation
No, we're not.
on what Mr. Bodette thought or didn't think.
Sustained.
So I don't have a problem if he wants to offer to prove. I don't have a problem if he wants to submit documents to the court as an offer to prove, but I think we've gotten outside that scope at this point, Judge.
We're well beyond the offer to prove. Do you have any additional information that you wish to get from this witness?
I'm sorry,
Are you done with this witness? I've sustained the state's objection.
No, I'm sorry. Okay. Did he identify any other sources?
Did he say it again? Sorry.
Did he identify any other sources?
He did.
Who?
Prosecutor McClelland.
And was he in communication with Mr. McClelland?
He was.
Judge, again, I'm going to object. I think we're outside the scope of offer to prove. And so at this point, I'm going to object to the continued line of questioning.
Duh.
The documents. The documents would establish that Mr. McClelland and Mr. Bodette were in communication. They were trading information. Mr. McClelland said he wanted to talk to other people in the group. Mr. McClelland sent Mr. Bodette a message telling him to delete everything. So that would be the testimony. And then lastly, I'm sorry, so he and Mr. McClelland communicated, and then any other sources besides the employee of Judge Gull?
Well, Judge, I'm going to renew the same objection. I think this is outside the offer to prove of why his testimony, of why these exhibits are relevant to the hearing today.
Sustained. We are done with this offer of proof, sir.
Oh, well, not really.
Yes, you are.
But I have a right to make a record.
Well, then make your record in a summary fashion, not through this witness, because you are violating any kind of offer of proof. You're just having him testify to information that you want to get into the record that you can't substantiate or support.
Okay. I absolutely respectfully disagree. But the only last thing I'll say is that the November 22nd of 2022 YouTube clearly establishes that Bodette had a version, what he called version 2.0 of the probable cause affidavit 1 week before it was ever available to anyone. That's it. Thank you.
Do you have any questions for this witness?
No, Your Honor.
All right. Thank you, sir. You may step down.
Thank you.
I recall Mr. Mullins. Mr. Mullin is sworn in. Thank you. Mr. Mullin, you have described your function in the prosecutor office organizing discovery and fashioning receipts as it was given to the defense.
I had my mic muted. Where am I?
Right here on the very top.
Yes.
From your duties in that regard, can you tell the court approximately how many external hard drives they were given?
Sitting here today, that would be hard for me to estimate, but several, probably 20, 25, something like that.
And then how many flash drives?
Again, difficult for me to give a quantification here at the moment without looking at my notes, but several, maybe. I like to maybe I can get some clarification about your question. Was that before or after they were removed?
Before. And then after they were reinstated.
Thank you. So before, probably maybe 15.
Okay, thank you. That's all.
Any questions?
No, Your Honor. Thank you.
All right. Thank you. You may step down.
I'm going to recall First Sergeant Holeman.
One second, what page?
Judge, can Mr. Rozzi be excused? And he's okay with me proceeding. Judge.
Sorry. That's fine. He's your client.
Okay, Sergeant Holeman, did you obtain documents or screenshots from Mark Robert Cohen?
Second, I'm still finding the page.
58 of the second part.
Yes.
And did he go under Funko Cohen 87?
I believe so.
I'm going to hand you what's marked as Defense Exhibit R and ask you if you recognize it.
I don't think I've ever seen these.
Well, do you recognize it as Cohen?
Again, I don't know if he went by Funko Cohen 87 or not, but I'd have to check my notes or re-interview him to see if that's actually him.
Okay. Well, then did you, in talking to Mr. Cohen or reviewing his material, it's your belief that Mr. Cohen received pictures from Fortson and then Mr. Cohen put them on the internet. Is that correct?
No.
Okay. Well, what did Mr. Cohen do?
He sent them to Anya Kane.
He sent them where?
He sent them to Anya Kane and Kevin Greenlee.
Okay. Did he ever tell you that he also had, or did the murder sheet people ever tell you that he also had photographs of clothing, shoe prints, indentations from a tripod, that kind of stuff?
No, I don't recall that.
Do you know a Mike Thomas?
I do.
Do you know if Mr. Cohen ever told anybody he had crime scene or he had seen photos and notes from Mike Thomas?
No.
Who is Mike Thomas?
Mike Thomas was the chief deputy at the time for Carroll County.
I'll withdraw R. Do I need to leave that with the reporter?
No. If you're withdrawing it, I'll just show it's withdrawn. Any cross, mister?
I'm sorry?
Are you done with him?
No. I got to find a file.
Okay. Hold on.
You testified earlier that one of the people you interviewed referenced the leak of the probable cause affidavit for the search of Mr. Logan's property.
In my deposition, I testified to that, yes.
Okay. Have you been involved in the execution of search warrants?
I have.
How many? A lot?
Yes.
Have you ever left a copy of the affidavit?
No.
You've always left a copy of the actual search warrant,
Yes.
but never the affidavit.
Correct.
And can you identify, are you familiar with the affidavit for that search?
I am.
And is State's Exhibit 5 a copy of that?
Yes. Yes, it is. Excuse me. Yes.
And then, did you ever explore or investigate why on this copy murder sheet is stamped?
Judge, I'm going to object at this point. I thought he was going a different direction. I don't think this has any relevance to what we're here to discuss today, Judge. I was giving him a little leeway, but I don't know where he's going and if it's relevant to what we're discussing today.
How's it relevant?
I'm sorry?
How is it relevant?
Well, it's relevant. One, they've opened the door because they didn't object when he testified about the Logan affidavit leak. And so that's already in. I'm following up on it. And it goes to the extent of this investigation of this leak and his choice not to do further investigations or investigations of other leaks. And he also testified talking to Miss Kane and Mr. Greenlee. Is it Green?
Greenlee. Yeah.
Who are the murder sheet people? So he talked about how he talked to them, what they gave him, and this is another document that has their little podcast thing stamped on it.
Well, to the extent that the state inquired, I'll allow it.
Okay, move to admit it.
Judge, just same objection, Judge.
All right, I'll show S. It's S, not 5.
Yeah,
Admitted over objection.
that's all I have for Mr. Holeman at this time.
Any cross?
No, Your Honor.
All right. Thank you, Sergeant. You may step down.
You ready?
You may call your next witness.
Call Mr. Brad Rozzi. Please state and spell your name. You're muted,
That's an
Brad.
imposter. That's an imposter, and he's muted.
Oh, there he is.
Bradley Anthony Rozzi. Last name is spelled Rozzi.
Still seems suspicious.
Well,
How
that's
many
weird.
different ways? How many different ways is that pronounced?
I don't want to get into that conversation. We'll be here all day, okay? But I will say that you've mispronounced it all day, David.
Rosie. Oh, David had?
Oh yeah, it was hilarious.
The press release, what day was that?
The day that, are you asking me about the date that it was issued?
Yes.
I believe it was December 1st.
The day
There's a lot of dates running through my head, but I believe it was December 1st.
Was there an order in place before that time?
No, there was not. No.
Were there conversations with the court about not intending to try the case in public?
Yes, there were.
Was the press release an attempt to do that?
It was not. No.
Well, what was its primary purpose?
Its primary purpose, first of all, it's something that was certainly thought out. It wasn't some, kind of random act that just occurred. There's a lot of strategy that comes with things of that nature. And, in my opinion, I think it was really the first purpose that it served from my point of view is that it communicates to your client that you're behind them, that you're behind them in terms of the endeavor that's ahead of in a case like this. So lawyers that are trial lawyers that know what they're doing, that are well-trained, will tell you that, hold on. Wait, let me get on mine. Sorry.
Okay, I thought you were on yours. Sorry. I
No,
wouldn't scroll. I know you can't handle that.
I know it's very difficult for me. I'm very old. So lawyers that are trial lawyers that know what they're doing, that are well-trained, will tell you, getting the client's trust and credibility is important. And so I think that that's one of the reasons why, at least in my mind, that I thought it was a good idea. The second reason is maybe more unique to this case. You've got, from the day that I entered an appearance in the case, I'm getting emails and phone calls, The office is inundated with those kind of things from third parties, from media sources. I mean, I can remember getting calls from NBC, from Rolling Stone magazine, from publications out of London. And at some point, Andy and I talked and just thought, hey, one of these things we can do is issue a press release so everybody knows kind of where we're coming from. And maybe we'll quell some of that, kind of put some of that to rest. And so that's why we did it. At least that's why I thought we did it.
One purpose was to stop random inquiries, correct?
Yes.
Another thought was to do it in a manner where you wouldn't be subjected to questions.
Oh, clearly. Yeah, for sure.
And then I'm going to approach and hand you Defendant's Exhibit T. Were you familiar with the extent when you were, describe when you were appointed?
I'm going to say late October of 2022, estimating.
And were you familiar then with the extent of state agent sponsored media presence and publications and press conferences and press releases?
May I review this?
Yes, you may. That states, Defense Exhibit.
Yes, I was generally familiar with it. A lot of these things were going on. To sit here and say that I knew about every one of them would not be accurate.
Is Defense T a summary of the dates and the communications from state-sponsored people?
That's what it appears to be.
What'd you say?
That's what it appears to be.
Oh, move to admit.
No objection,
What?
Judge.
What'd you say?
What?
All right. I'll show T is admitted without objection.
What then? Was the press release an attempt to influence the public?
No, sir.
Was it a plea for tips?
I'm sorry. What was the question?
A plea for tips from the public, information from the public.
Well, I think that we were aware that there could be one of, the side effects, or should I say the result of that. But I don't know that we sat and had any real discussions about that in great detail.
Did, in fact, you get some tips?
Did we get some tips?
Yes.
Oh, yes, certainly.
Were any of them of any value?
Oh, very much so, yes.
And did you know that the Indiana State Police, sometimes with the prosecutor's office, sometimes without, and had a constant presence in the 5 years since the discovery of the bodies, issuing statements and revealing a little bit of information, asking for tips from the public?
I am aware of that.
So what happened was I'm sorry, was there a question before him?
You're asking me the question, sir.
Yeah, I got interrupted. Did you have anything to do with the email to Woodson?
Mr. Woodhouse?
Woodhouse.
I did not. Well, I did not have anything to do with the initial email. I clearly had something to do with reporting it when I learned about it in March of 2023.
Did you get emails from Mr. Baldwin the day Mr. Westerman had? Or no? Did you get an email from, strike that. With regard to Woodhouse email, were both you and Mr. Baldwin fully cooperative and truthful to the court as that was discussed?
Yes.
With the Westerman leak, did Mr. Baldwin advise you the very day that Mr. Westerman confessed to him what he had done without permission?
Mr. Baldwin, well, Andy called me on the day that I believe that he learned of that and basically reported that to me. And then, yes, we followed up and we decided that we were going to call the prosecutor and the judge.
Was that reported immediately to the prosecution and the court?
Yes, after I learned of it.
What did you say?
Jesus, get a hearing aid, David. It was reported immediately after I learned of it, for sure.
Well, right. But you learned of it the day Andy learned of it.
I believe that's true, yes.
Have you reviewed during the break the state's exhibit of the 5 pictures?
Yes, I had a chance to look at it during the lunch recess.
And were you present for Mr. Holeman's testimony that he was presented with all of those pictures at deposition?
Sorry, could you ask it again?
Sure.
It's a little hard to hear, and we've got a computer between us.
You want my hearing device they've been giving me?
No, it's fine. I can't really see you that well. Just go ahead and ask the question again.
Did you, Were you here when Sergeant Holeman testified those 5 pictures had been presented to him at a deposition at which you and Mr. Baldwin were present?
I was here, yes.
And over break, did you go back and contact the court reporter and get all exhibits that were presented to Sergeant Holeman at that deposition?
I did, yes.
Were all 5 of those pictures presented to Sergeant Holeman?
No, they were not.
Which ones were not?
Can I see the exhibit?
Strike that. It's under seal. Well, no. He's described. What exhibit? I think it states 6. I'm going to hand 5. I'm going to hand you states 5, which has been admitted over objection. Can you please go through there and describe generally which photographs were not presented to Sergeant Holeman?
Photographs 3 and photographs 4.
What?
I'm not going to talk about the details.
Okay. Well, neither have they, but 3 and 4 is not helpful. So there's a picture, and they've already said one of the victims that has blackout marks, including a dash and a circle.
4.
Could you find that one?
That's the 4th page
Okay.
of this 5-page exhibit.
Was that presented to Sergeant Holeman?
It was not.
Is that something the defense ever prepared?
No, I haven't, and I don't believe Mr. Baldwin has, because I was part of those depositions, and I haven't seen this before.
So you've never seen that before?
I have not.
And to your knowledge, that picture was never given to the defense?
No. I literally just looked through the exhibits when I was at lunch, and this is not one of them.
Okay. What was the other one?
It would be the 3rd page of this 5-page and this 5-page exhibit, which is it's a handwritten diagram. It looks like almost maybe, I don't know, pencil or crayons or something.
Is that the handwritten alleged diagram of sticks and like a roughly drawn person with sticks placed around them? Or did that?
Yes, sir. That's a fair description.
Have you ever seen that before?
No, I've never seen this.
Was that ever presented to Sergeant Holeman at the deposition?
It was not attached to the exhibits that I looked at that were given to us by the court reporter, and I believe it was absolutely not.
Judge, I want to make a point of clarification. I think Mr. Hennessy has mischaracterized Mr. Holman's testimony. I had to look back at my notes. What I remember Mr. Holman saying is some of the photos were from the deposition, not all of them. So that's my recollection of the testimony from Mr. Holeman. So I wanted to clarify that for the court, Judge.
Okay.
Well, the record will speak for itself. And I guarantee he described the circle part because I wrote that down in my notes with question marks, wondering what he was talking about. And then it came out later what he was talking about. Were you present at an unrecorded conference in chambers where the protective order was discussed? What'd you say?
It was the gag order. I think that's what you're talking about.
Okay.
And yes, I was present.
And what was the discussion?
The basic discussion was that Mr. McClellan, myself, Mr. Baldwin was there, I believe. I'm pretty certain former White County prosecutor Robert Guy, was present at this particular conference. I know it took place in Delphi, and I remember the discussion was prompted by the lawyers communicating to the court that we felt kind of handcuffs because we had these orders in place, and we really didn't know who we could even talk to, like a potential witness. Could you share any information with them, to try to determine their credibility or to corroborate information that they were giving you, these kind of things. I mean, I feel like even the prosecutor, communicated that it was kind of an odd space that we were working in. And we just really didn't know where the fog lines were, so to speak, on the road. And the judge was kind enough, frankly, to have a discussion with us and try to define, where those lines were. And, my recollection of the conversation is basically, Your Honor told us that, this is primarily intended to keep us from releasing information to media outlets, to having press conferences, to doing what I consider kind of a more traditional media type relations, if you were, I guess, in a case like this. And so that was the nature of the conversation that we had.
Was it expressly discussed that you could discuss evidence in discovery that you'd received with people you wanted to consult with for trial preparation?
I can't say that was the exact discussion that we had. I think that it was more along the lines, if it's not the media, then it's okay.
Did you watch Barbara McDonald's report on Court TV?
I did.
In watching that, did you notice stuff that she had that could not possibly have come from the defense?
Objection, Judge. I don't see what the relevance of that is to this hearing.
How's it relevant to the hearing, sir?
Well, it's the same response as before, but on this one, I'm adding it could not possibly come from the defense, which it goes directly to the issue of what defense did provide, what defense didn't provide. And he's prepared to testify. He saw her with stuff that could not have possibly come from the defense. And he's testifying on his own behalf on a...
Overruled.
Do you want the question again?
I saw her, holding what I would consider part of a report and talking about it openly. And it's certainly something that I knew was a part of the discovery, and it wasn't provided by me. And I'm fairly certain it wasn't provided by Mr. Baldwin, because both of us were pretty surprised that she was talking about this openly, to the entire viewing public.
And wasn't there something about sticks?
Well, it was the Purdue report is what it was.
Okay, and
I'm not even sure we had it at this point. I could be wrong, but if we did have it, it was just right close in time. But I actually don't think that we even had it. I think that later, when I saw the report, then it was brought to my attention that there was this broadcast, and I watched the broadcast, and it was the report that I had just gotten. And I actually shared that with the court just for context.
I'm going to approach you and hand you an envelope that is marked Flash Drive Barbara McDonald interview on Court TV. Do you recognize that?
I do.
And was that preserved on a flash drive?
Yes.
Look inside. Tell me if that's the flash drive.
Yes.
Thank you. Move to offer Barbara McDonald on Court TV, Defendant's Exhibit U.
Judge, same objection to relevance. And also, I believe it's hearsay. I haven't watched the report, but if it's going to be her testifying about what she's gotten and what she believes is leaked, I think it applies to hearsay, Judge.
Any response?
Same response.
All right. I will show that U is not admitted as hearsay.
Are you familiar with the Indiana Public Defender Council's performance guidelines?
Generally, I am, yes.
And have you lived up to them?
Yes.
And is brainstorming and war rooms for trial prep common within criminal defense counsel and considered essential to trial preparation and adequate representation?
It is.
And then are you familiar with the Indiana State Police typical protocol for investigations such as the one at issue here?
I actually do have some knowledge of their general protocols, yes.
And how do you have that?
Because I've represented state troopers that have been accused of crimes. I have a brother who's one of the chief detectives at the Peru post, and I talk to him routinely. I'm very familiar with what goes on in the state police, investigative ranks, so to speak, and a lot of friends and a lot of other clients that work in the field.
And what would be their normal protocol for an investigation of leaks by defense counsel in a criminal case in which they were involved?
Well, I've never been involved in a case where there was an allegation of a defense counsel leak, but I've certainly been involved in cases where there were, let's say, ethical issues at stake, and they typically farm those out to other posts. In fact, I had a meeting with one of their, I think they call them their internal investigative unit or whatever. I actually had a meeting a week or two ago with a client with an internal officer, and so they're typically farmed out to other posts so that there's some separation of the activities, some independence.
Thank you. Without getting into them, are you familiar with, from your review of all the discovery provided on this issue, that they've given us over 100 pages of Fortson stuff? They've given us Westerman stuff, Cohen stuff. Are you aware of other leaks that cannot possibly be connected to the defense?
Objection, Judge. Relevance.
Just in general, we're not going to get into it, but whether he's aware of it.
I think you've made your point, Mr. Hennessy. I'll sustain the objection.
Did both you and Andy, it's in evidence, you wrote a letter to Judge Gull. The state introduced that into evidence.
Okay.
You recall that?
Regarding the Westerman issue or situation?
I can't remember.
Yeah, I know I wrote a letter to her in the fall. I'm not sure. I might have done more than that. I might have written more than one. So
Are you positive that you and Andy cooperated fully with candor and honesty to all inquiries by the court regarding anything at issue here?
Yeah, I sat down with Officer Rector and signed an advisement of rights and answered every question that he asked me immediately after we heard all of this.
That wasn't the question. The question was, with the court, any questions asked by the court, did you respond? It's Rule 3.3 of the Indiana Rules of Professional Conduct. Respond, candor versus the tribunal. It only applies when the court asks questions. Did you and Andy respond with full candor, honesty, cooperation to any question from the court about anything at issue here?
Yes, sir.
That's all I have.
Mr. McQuillan?
Thank you, Judge. Mr. Rozzi, I think you said this, but I want to make sure I'm clear. I want to start back in the beginning with the press release. You concede that there was an in-chambers meeting before you and Mr. Baldwin made the press release where you told the court, Judge, there's no reason to issue a gag order. We're not about trying this case in the public or something to that effect.
I think it was not that. There was a discussion in chambers, generally speaking, which I frankly think you prompted about trying this case in the public. I do acknowledge that.
And in that meeting, you said, Judge, there's no need. We don't consent to the gag order. There's no need for that gag order. Do you recall that?
I think that's a fair summary of the conversation we had.
And then after that is when you agree that after that is when the press release was put out by you and Mr. Baldwin.
Yes, sir.
Okay. The email that Mr. Baldwin sent to Mr. Woodhouse, when did you find out about that?
I found out about it on the day that we reported it, which I think it was someday in March. I think what I later learned was that it occurred maybe in December. And frankly, I'd already forgotten the date on that, but I found out about it in March and then reported it immediately thereafter.
And do you know, was the email sent before or after the gag order was put in place by this court?
Mr. McClellan, I really don't know. I'd have to look at the dates.
And do you agree that perhaps not all, but some of the photos that were leaked by Mr. Westerman are photos that the defense created from discovery provided by the state?
Well, I don't know exactly what Mr. Westerman did. You know, I wouldn't know Mr. Westerman if he were sitting in the chair next to me, okay? So I don't know what he did.
So the answer is?
I saw, so the answer is no, I don't know.
Okay. The photos that you saw today and state's exhibit, some of those were those created by defense, specifically the side-by-side photos.
Those look familiar to me from the deposition of Mr. Holeman from early August. They do look familiar. I mean, of course, they're kind of screenshots of screenshots, so it's kind of hard for me to sit here and say that's exactly the document that we prepared. I'm not trying to get overly technical, but, you know, they might have been reproduced.
Okay, so I guess what is your answer? You don't know, or?
I'm not really positive.
Okay.
You know, I don't know.
Okay, I don't have any other questions, Judge. Thank you.
Mr. Hennessy?
Can I have a minute?
Sure.
No redirect.
All right. Thank you. Mr. Rozzi, you may step down.
Thank you. Thank you. It's been a great day in court. Thank you, everyone. I want to go relax, have a beer, maybe a martini at the local bar. Talk to you later.
Thanks, Mr. Rozzi.
Again, martini.
Again.
You may call your next witness.
I have no other evidence on behalf of Mr. Baldwin and Mr. Rozzi.
Any rebuttal?
No, Your Honor. Thank you. Oh,
I'm sorry. I'm sorry, Judge.
Any rebuttal evidence?
No, Your Honor. Thank you.
What?
What you say? What you say?
Any argument you'd like to make, Mr. McClellan?
Judge, I'd like to just briefly, I'll try to keep it short.
Sure, go ahead.
I understand we've taken a lot of the day, but Judge, this is a unique situation. I can honestly say I've never been in a situation where we've had to handle this kind of issue. From the state's perspective, this started in our first in-chambers meeting back in November of 2022. My recollection of that is that we had an in-chambers meeting And I had the gag motion in hand, and defense said, there's no need for that. We're not about trying this case in the public. And then just a few short days later, the press release was issued. The court issued the gag order in response to that press release. Again, the state's belief is that from the evidence, that was an attempt by the defense to try this in the public and push their narrative of this case out to the public. That in itself, not a huge deal, Judge. We've addressed that. We've moved on. Then we move on to the email sent by Mr. Baldwin. The state does believe the gag order was in place when the email was sent. The court can take a look at the documents that we submitted under judicial notice, and they show the email was sent in late December after the gag order was sent. I think it's in violation of the gag order because it disseminates information, specifically witnesses' names and what evidence exists in the case, out to the public. Mr. Baldwin said that he contacted Mr. Woodhouse and had him delete it and didn't come forward and tell the court until the state found it in March of 2023. And so I think there was a violation of the gag order that both parties failed to report. And I think that is something for the court to consider as well. And then we get to the most egregious, Judge. In the state's mind is the leak of the photos. We got notice, the state got notice in the beginning of October that there was a leak. We began an investigation. There are several emails I submitted to the court where the defense says the leak's not from us. We've had all our people sign NDAs. We think it's from law enforcement. We start to track down the leak, and as we get closer and closer to the source of the leak, Mr. Baldwin and Mr. Rozzi come forward and say, we know who the leaker is. We'll tell you it's Mr. Westerman. He broke into my office and took some pictures and leaked them. I think Mr. Hennessy used the word snookered. It wasn't our fault. We didn't know he was doing it. That's where the leak came from. As we continued to investigate, we pulled documents from Fortson's Facebook page. I think it's clear from the Facebook messages that the leak was not just the pictures, it was ongoing. Mr. Fortson has information privy to only the defense. When Mr. Baldwin's coming up to Fort Wayne to drop off exhibits, and when he's meeting with Mr. Rozzi, when the information about the Purdue professor came out, information about the girls' cell phones. So all that information shows a continuing leak by the defense to Mr. Fortson. We don't get an opportunity to have Mr. Fortson here today because in the midst of this investigation, he commits suicide. And the information that we have is that at least part of his reasoning is that he was concerned about the investigation and the facts of this case. So we proceed forward with the investigation. We interview Mr. Baldwin and Mr. Rozzi, and Mr. Baldwin changes his story a little bit from what he told the court and the state on October 10th. He now says Mr. Westerman is a consultant and that he's given him the Franks motion. He consulted with him about the Delphi evidence. That's his information that he gives Detective Rector when he interviews him. And so his story changed a little bit. In the meantime, Mr. Westerman files an affidavit with the court, and the court has that. Mr. Rozzi writes a letter to the court. The court has that information as well. And then we get to the search of Mr. Westerman's iCloud account, and we find out that Mr. Baldwin's talking directly to Mr. Westerman and releasing evidence, stuff about the crime scene, what the victims are wearing at the crime scene. And the ironic part is now Mr. Westerman apparently has turned into an employee of Mr. Baldwin because they made an objection that those messages are now work product.
No, I'm going to object to that. Objections aren't evidence, and that's been clear and been the law forever. And the fact I objected can't be laid at the feet of Mr. Baldwin, the client, and the objection was work product based upon the mental impressions of Baldwin. It didn't go to the Westerman stuff, so no, that is not making Westerman an employee. I object to the form of argument.
Overruled.
What?
What'd you say? What'd you say, Judge Cole?
And so it seems that Mr. Baldwin wasn't entirely honest with the court on October 10th phone call. And it seems, as we've gathered more information and we dig deeper into the investigation, again, we show an ongoing leak where the evidence only could have come from the defense, and it shows an ongoing leak. And it appears from Mr. Fortson's message that the goal of that was to push this narrative out to the community or out to the public to gauge their response. We even heard an attorney testify. He does that with his sisters. So it's not completely outside the realm to think defense was doing this purposefully and intentionally. And so, Judge, given all those things, we believe the state has proven the information outlined and the contemptuous information has been proven. It's not up to the state to recommend sanctions, in my opinion. That's left to the court. What the state wants is just to be able to move forward with this trial and make sure that everyone has an equal opportunity at trial, not only Mr. Allen, but also the state. And I guess I'll leave you with this, Judge. If the shoe were on the other foot and I had leaked these photos, or a friend of mine had leaked these photos, I can guarantee the defense would be screaming from the mountaintops, not only to have me removed from the case, but disbarred. Look at how much they've attacked me personally already in all their filings. And so I think it would be a totally different story if this was a leak committed by the state. The defense wants you to believe that, oh, it's not a big deal. It wasn't our fault. It doesn't matter. It doesn't matter, Judge. It does. These are intimate photos of a crime scene that are leaked to the internet. And we still don't know if we have them all. We never will. And so the families have to risk every day when they get on the internet, risk opening a page or getting an email from somebody or getting a communication from somebody that has these photos attached. And that's the real damage, Judge. It opened the public, the potential jury pool, and everybody in the community up to evidence that's only presented at trial. And so for given those reasons, Judge, I think the state's proven that the information and the contemptuous information have been presented to the court. Thank you.
Mr. Hennessy?
Well, the hyperbole at the end has no foundation in the evidence. We don't know if they're still out there. We don't know if we have them. The family has to live in fear. Yet Holeman, Mr. Holeman, Sergeant Holeman, when I'm asking him, there are people reporting that other people have the photographs, but he didn't go investigate them. He didn't go try to get them. So if they're still out there, it's because they didn't do their job to go get them. All after the leak that cannot be willful on the part of Mr. Baldwin and Mr. Rozzi's, not even involved with it. The press release, there's a case that says contempt isn't used to correct if you offend the sensibilities of the prosecution or the court. I get what they've said in their mind. The press release had a legitimate purpose of not trying the case in public. The state did the same thing, only much longer and much more detailed. They did get tips, and it's helped the defense of Mr. Allen. It did not persuade the public because this case has been on fire from day one. And you've had two camps, and they fight each other. They got in a fight out here, and they go back and forth. They speculate. They get leaks. They make leaks. So no, they did not influence the public. The email to Woodhouse, and I apologize if there's a Mr. Woodson anywhere for continuing to butcher his name. How does that violate the gag order? The gag order says public dissemination. It's an accident. It happens to everybody. And you had 3 extremely experienced lawyers testify that they did exactly what Mr. Baldwin did. The evidence, and it's in Sergeant Holeman's report, that within an hour, as soon as he discovered it, he contacted Woodson, told him to delete it.
Called him Woodson again.
It would never cross my mind to report that to anybody because I would consider it cured. So 1, it wasn't to the public. It wasn't to the media. It wasn't public dissemination. It was a mistake, an accident. With regard to the photos, they kept trying to connect Fortson to Mr. Baldwin. There is no evidence. In my cross-examination, I can't remember who it was. Might have been Detective Rector. Whoever was talking about the Fortson thing, there was only one reference to Andy. And it was not, I talked to Andy. This is from Baldwin. You do have Andy and the rest of the evidence about Westerman from his 2-hour interview and other communications to the police and prosecutor in court is that Westerman has a law degree, but he is not an attorney. He is considered by Mr. Baldwin and other lawyers to be a highly skilled strategist. Many people consult him for trial preparation. It was conceded, I think, and Mr. Rozzi testified that was a function that was permitted by the gag order. Mr. Fortson is only connected to Westerman, and they should have produced Westerman and Fortson clearly had other sources. So there's no direct connection from Fortson to the defense. So their whole theory of a continuing leak to the public is not founded. What they were talking about was between Fortson and I want to say Cohen. discussions between them. But everything they pointed to, the Franks memo, everything referenced in that series that they went through never appeared in the public arena. It was never went on a podcast. That was only some of the photographs that Mr. Westerman took. And again, how can that be willful if you take something from me? You've got to know something about it for it to be willful. And there's no connection to that. There just isn't. I won't repeat the law on the burden. I would ask that you look at my memorandum that I filed in advance of today. Trial courts don't have jurisdiction to enforce the rules of professional conduct. To the extent any of this should receive a review upon a complaint to the disciplinary commission, that's a separate issue because this is a criminal contempt proceeding. The trial courts don't have the jurisdiction to do that. And then lastly, I was going to ask, now that the evidence is all in, if I could do a subsequent memorandum. Since you granted specific findings of facts and conclusions of law, I thought perhaps we'd have time before you rendered a decision. So if there is time and you're going to take some time, I would like to do a post-hearing memo. Thank you.
Any final thoughts, Mr. McQuillan?
No, Your Honor. Thank you.
So how much time do you want for a post-hearing memorandum?
I could probably get it done in a week.
And then will the state ask for time to respond to that?
Judge, yes, because I'm not sure what he's going to put in there, so I better have time to look at it. If I could have a week after that to respond, Judge, that would be sufficient.
So I'll give you, Mr. Hennessy, until March 25th to file a brief. The state would then have until April 1st, and then the court would also take its 30 days to rule. So that puts the week prior to trial. Is there anything else from the state on the contempt information?
No, Your Honor. Thank you.
Anything else from the defense?
No, ma'am.
All right. It's just a little bit over 3 o'clock p.m., and I would like to do the motion to dismiss that was filed by the defense. Why don't we take a quick break? We've been sitting here for a couple of hours.
What?
What'd you say?
What?
What'd you say?
Since you brought that up, I want to say something because in the back chat, CJ said that the Gremlins were saying how sloppy Hennessy was in his defense and how bad it was. I didn't get that vibe at all from reading through this. And it reminded me of something that Fiend had actually said yesterday when we were reading the other one. And he basically was trying to point out that in reading this, Hennessy sounded even better than in real life. And that basically her denying cameras, that this is going to read really well to the appellate court versus them watching it.
Yeah, like in my opinion, I mean that's what Hennessy's entire goal was here, was to make a record. You know, I mean, frankly, Osbrook's motion should have won because everything that Osbrook wrote in his motion for this thing to be summarily denied was like on point, 100%. You know, it wasn't filed under its own case number. It wasn't a proper hearing. It shouldn't have taken place. And, you know, because it was, you know, Hennessy was adamant. He's always adamant about making a record, which I always appreciate, especially in a case like this where Gull has historically not been very good about making a record. So I really appreciated it. You know, and Dave was tired. Like, that was a long day, and the way that the courtroom was set up, defense table, counsel's table was way over to the far right of the bench, and so he'd have to walk around the back of the courtroom right in front of the bar of the court, and then go around to Cleveland, and then they had the podium set up on the left hand side, kind of parallel to McClelland's table, and then the witness box was right there. So it was just a lot of walking around. He's an old guy, you know, and it was like a long day. So and this is after lunch. So, you know, 2:20, 2:30, whenever this thing ended, he was out of gas, you know, and he couldn't hear shit. Like it's like that room is huge. It's a huge courtroom, beautiful courtroom. And on top of it, it's got a big, beautiful domed glass in the center of the ceiling, which looks gorgeous, but makes for absolutely shitty acoustics. So, I mean, I could barely hear shit. I had the, my hand cupped to my ear almost the entire afternoon.
What'd you
Seriously.
say?
What?
For people
What?
for
What?
people not having been able to really hear what was going on, I feel like now, having read the transcripts, which provided me different information, and there are a couple things in through there, if we're going to do like another part 3 to kind of pick out things that stuck out to us, but um I think people did really well, like all the compilation of notes that we got and then put in that one PDF. I felt like everybody did a really good job about covering. Now, granted, some people didn't mention things other people said, but as a whole, they included everything. It felt like everything was included.
I agree. I don't think there was, like, as reading through it, like, I don't think there was any surprises, like, holy crap, how
Yeah.
did nobody catch this? I thought,
For
yeah,
people,
really
that fish at the Sphere is amazing. I've live streamed it the last 2 nights. It's like unbelievable. If you like fish, I happen to love fish, and that, like, they're at the Sphere in Vegas, and it's some next level shit. It's crazy.
Bob, I want to ask you something.
Okay.
Because you've obviously like seen more orders from judges than me, but I've never seen orders on motions, like rulings, that just basically say granted or denied. Like, is it normal that, are there other judges that normally, as like their standard practice, they put their rulings in as just that, like no extra explanations?
I mean, it depends. I mean, if it's a case that's not massive, it's not unusual to get, sometimes they won't even take it under advisement. Sometimes they'll rule right from the bench. But typically we've given them the case law, and the statutes that we're arguing that apply, and the judge will have done some research ahead of time, and then, they'll hear the witnesses, and then, they'll have a pretty good idea which way they're going to rule ahead of time, but they will give their basis in the law.
Yeah.
That's the thing that's missing with Gall, is that she's not like Andy's not being snarky. I mean, he is, but he isn't when he's asking for them, like giving, like actually in the wherefore clause, asking her to make conclusions and findings of law. You know what I mean?
Yeah.
Because that like in a case like this, where if there's a conviction, you are guaranteed there's going to be appeals. You need to have an appellate record. And if
Yeah.
she's not giving an explanation as to why the court denied a motion, it's of no assistance to the appellate court. And frankly, it creates more work for them. I mean, the Supreme Court could not have been more clear about that.
Yeah.
Like
Like,
they told her flat out, make a better record. Like, what
yeah.
are you doing? So, I mean, it's not necessarily unusual. I think that she's improved slightly in terms of her reasoning. I mean, the first couple that she, filed after the Supreme Court hearing, she was still doing the same thing. I think more recently, she's at least trying to give some basis in the law, but it's a far cry from what you'd expect. And these suppression motions, she's going to have to make a ruling and give legal conclusions if she's denying it. She just can't sit there and give just a broad denial with no support in the law behind her decision. So,
like for Karen Reed's case, like whenever Judge Bev will take something under advice, usually not like the short things that she can kind of just spout off while they're in court, but if she takes something under advisement, she'll write like a 10 to 15 page order, like a memorandum explaining a bunch of like
well, that's what you want to see.
Yeah.
I mean, that's what you want to see. You want her to cite the cases that she's relying on in her denial. I mean, that's the entire practice of law, is based on precedent and what precedent applies and what doesn't. I mean, the entire practice of law boils down to interpretation. One side, two people look at the same statute or the same fact pattern, and they have entirely different interpretations of what they're looking at. I mean, that's literally what the practice of law is. So then what happens is they'll say, okay, well, I'm going to make a legal argument, and they're going to go into Westlaw. They're going to pull up case law that's going to support their position or that they believe supports their position. And, that's the cases that they'll submit to the court, and both sides do it. And ultimately the judge is going to say, okay, well, I agree with either the state or the defense. I think that blank case applies here. And I think that it's on point. And, and she's just not doing that, and when you get to the more substantive motions, such as motions to suppress, the Franks hearing, like where she didn't give an explanation as to why, I'm not concerned with her giving just a summary denial on the contempt motion, because it didn't mean shit. It really didn't. I appreciate the hell out of Teresa getting this, because I think it's important for people that still don't have a grasp of what I've been saying for 5 months, that this thing doesn't fucking matter. It just doesn't. It has nothing to do with the underlying trial. The only thing that mattered was whether or not the leak was going to affect the public in terms of tainting a potential jury pool. Because the only thing that matters at this point, and it's not to say that we don't care about the victims getting their justice, because that's goes without saying. Always. It's always overarching. That's the whole point of having a trial. I shouldn't have to repeat that. But at this exact phase of the proceedings, what we're concerned about are Richard Allen's rights and making sure that he gets a fair trial. That's it. And when I keep saying it, and like my whole thing with who benefited from the leak, McClelland did. I've been saying that for 4 months. That guy was not ready to go to trial on January 8th. And any prosecutor that wants to come and tell me that they think that Nick McClelland was ready to go to trial on January 8th is full of shit. There's no way he was ready. And the only person that benefited from that was him, because he got the time that he needed. He was going to get a year when she booted him. But when the Supreme Court fixed her fuck up, he still only got 6 months. But it's 6 months he didn't have when they said that they were ready to go in October. I mean, like it was like a full bowel movement in his pants when they said that. I guarantee it, because they have the burden. The defense doesn't have to put shit on. Nothing. They don't have to do a thing. They could literally go into court and not put on a case and just be relying on the fact that McClelland wouldn't have been ready in January to put on this case with all of this evidence and all of these witnesses and all the work that it takes. And that was my thing. My thing with McClelland was like, and I said it. I'm like, look, like, I feel bad that Nick McClelland isn't spending his time on what he needs to be spending his time on, which is the trial, instead of this thing. Like he was working on this for weeks that he can never, ever get back. And I'm here to tell you, I know none of you have tried cases. I have. I've done it for 20 years. Believe me when I tell you this, the next 3 weeks are a blink of an eye. They're going to all be waking up and be like, holy fuck, it's trial day. That's it. There is not enough hours in the day to prepare. And he was doing a disservice to himself by wasting his time on this thing when it could have waited. She's not booting them off the case. It's not an option for her. You understand? That's not something she can do. So, they should have just waited if he was still hot for him to get him sanctioned. Because if they're going to get a real ding, it's going to come from the disciplinary committee after the fact. If she finds them in contempt, it's an automatic referral to the disciplinary committee. They're going to see it, and they're going to make an inquiry. And then Brad and Andy are going to have to write letters in support, or have somebody hire a ARDC or wherever they call the disciplinary committee in Indiana to say, look, this is our position on it. And then at that point, if the disciplinary committee thinks that that's not sufficient, then boom, they go and they have a full hearing on it. So, it's like, and then they'll issue whatever discipline they're going to give them. It could be a fine. It could be a public sanction. It could be a public censure. It could be a suspension. No one's getting disbarred on this thing. They didn't do anything that was even close to being disbarred. They didn't do anything that was even close for her to be able to remove them from counsel and just absolutely jam a stick in the gears of this trial. It's like, I don't know. I'm just ready for this thing to go to trial.
Me too. But I have to ask,
It's
why
time.
do you,
Fuck all the bullshit. Let's go.
why do you think that Nick chose to waste his time with
I have
this?
no
'Cause that's
idea.
the part I can't figure out.
I cannot figure out why.
Time.
Because if Luttrell and even Diener at that point, like if they're in his ear, they have to be saying, Nick, dude, I want you here. I want you to walk with me. I want you to walk with me into our war room here. And I want you to look at all the shit that we have to do. Do you think that you should be spending 2 weeks on this shit? Because I mean, he didn't even deal with the motion to dismiss, which actually was relevant to the underlying trial, the trial that matters. Like
I found that part interesting.
Well, I mean,
you're not gonna tell me he was tired. I mean, he's not been doing this for decades. And so it's not like he was exhausted after that contempt hearing. And he even said because at one point in the beginning, Hennessy was like, I think he should recuse himself because he needs to testify to like conversations that we had. And he was like, there's 2 other prosecutors here that can do this. And he was like, neither of them are prepared. I'm the only one that's prepared. And it's like, well, so have they been doing your job and you've been fucking around on this?
do you guys just like, I say it constantly, like, does everybody in the chat understand how quickly time is going to move? Does everybody, like, when you guys watch a trial, when you watch a trial, do you have any concept of the amount of work that goes in by the attorneys to get that thing ready to present at trial? Both sides. I mean, like, it's like
22 days left.
Oh my God, I can't even, like, the subpoenaing of the witnesses, just all the mechanical shit, like the things that you just have to do to get everybody lined up to present a trial. And again, the burden's all on the state. McClellan has to be getting everybody lined up, all of his experts, which includes getting them housed, getting them traveled in from if they're out of state, getting them fed, making sure that they're lining up with their schedules, making sure that the other witnesses are available on when they're anticipating, putting together your directs and your cross examinations. It is like a beyond gargantuan amount of work. Like I've tried cases like this, and it's like it took us 3 years on Garcia, and I still probably could have used another year, like, honestly, because like, and they still got all whatever motions they're going to get filed, and there's going to be a litany of motions in limine that are going to get filed right before court, probably in whatever she's going to set for the last pretrial date, and that's she'll give a deadline for motions in limine, and it's going to be like you saw in the Reed case. They had 30 motions up. Now, granted, many of them are just kind of housekeeping issues, like motions to exclude, motions to sequester witnesses and things of that nature. But you're also going to have pertinent things in terms of things that both sides are going to be arguing shouldn't be admissible in terms of things that are said. That's where you're going to hear some argument about what level of the crime scene photos should be allowed to be displayed in court. And what, because it's a tenuous line of what's too much and what's not enough. You don't want it to be prejudicial in terms of, you've shown too much to the jury, and now they've just slipped into the emotion zone where they're not going to be able to focus on the law and the facts. They're just going to be coming from a place of emotion, which all of us do naturally anyway. We're emotional creatures, by nature. So, like, you're having to, when you're sitting on a jury in a case, you have to be able to push those things back the best that you can in terms of not coming from a place of emotion and say, okay, my God, I like these 2 girls, I'm devastated. I'm sitting here, like, I'm devastated. I'm crushed. Somebody's got to pay for this. And you have to be able to put those to the side and say, okay, but I need to just focus on the facts and the law. And that's the only thing that I can base my decision on, because I say it all the time, and it sounds cruel and callous, but it's not, because emotion has no place in the law. None.
Well, I had a question, and Sluthi, this is something that I believe we talked about last night, but stop me if I misrepresent it, because I've slept since then. You know, I know this.
Good.
I have an opinion on the contempt piece, and I think it kind of falls in line with yours, Bob, in the sense that obviously it was very traumatic to the families. I get all that. However, in my opinion, this was a gigantic waste of time, and it is concerning for me just reading through this. It's my opinion that the defense had a lot more to bring in. I know the judge wouldn't allow some of it because of hearsay and whatnot. I think on a future live, Michael Osbrook had a little bit more to get into on some things he found that show the leak did not come from the defense. But either way, whatever your feeling is, whoever side you're on, Nick could not bring forward one thing to show Baldwin did this willingly, knowingly. And so, Sleuthie, last night we were questioning and obviously I do not expect this to happen. I'm just asking, is it possible? In other cases where something like this would happen and so much time and effort was wasted on it, could the prosecutor get his hand smacked a little bit? Like, damn, dude, this is what you brought? I mean, he's asking for disciplinary actions against.
By whom? No, the short answer, I know exactly what you're saying. His hand smacked, like the most violent smack in the world, in the history of smacks, would be if Richard Allen is guilty and he walks because Nick McClellan wasn't prepared to go to trial.
That's what I said.
That's the smack. So, you know, if you're asking me if the disciplinary committee is going to come in and do something about it, no. I mean, no. I mean, they're you know, I mean, those are tactical decisions made by attorneys, and if he's acquitted, there is no appeal. The state can't appeal,
right?
You know what I'm saying? So no, there is no recourse. Nick McClellan would have to walk to the families in what would be the most horrific. I just rewatched that 5-part Made in America, the OJ thing, like last night. I like binged all 5 of them. Everybody in here should watch that. That trial was fucking unbelievable. It was unbelievable. And it was such a mix of everything. And the defense in that was brilliant, you know, and it was so controversial about what was going on. And it was like, you know, you're coming out of the Rodney King verdicts, and you're coming out of the riots, and you know, it's just like it was so well done by the defense there, you know, and it's like you have jurors in that case that say, you know, flat out, this was payback for those white cops all being found not guilty on the King verdicts, you know. So it was like it's such a, like, I'm super tempted, if I didn't have so much shit going on, to stream that trial, just because I can give me and Allison do it and have a bunch of guests on, because it was the first trial and CNN was the only thing that was running it, and it was the first time they'd ever done it, and it changed the way that we view the law. It gave people an understanding. We would not be existing in terms of the Teresas of the world and the Bobs and the Allisons of the world and the Sleuthies on her Twitter. And if we were not seeing these trials, you know, I mean, like that move changed the day. It changed everything. It gave the public a real glimpse into what the hell is going on in these courts. And that was the purpose of the Constitution. That was the purpose of saying it was trials were to be public. Now, obviously, back when they drafted the Constitution, TVs weren't even a fucking thing. You know, it was carrier pigeon type shit. You know, it's like writing with quilled pens and shit. So, you know, but they wanted the courtrooms to be open to the people, for them to come in. Now, obviously, we've moved way beyond that, and we can watch it en masse. And it's important. It's important. And this trial, and you know, and I've grown weary of people misconstruing what I say, because I could not be more clear. I think the PCA leans innocent, period. No one's changing my opinion on that. If he's the guy, they need more. I've said that like 1,000,000 times. I cannot stand one more person saying that I'm saying that Allen's innocent. I have no clue. Despite whatever everybody from the murder sheet thinks, I am not a shill for Brad and Andy. I have no idea what the discovery is. None.
What'd you say?
Whatsoever.
What'd you say, Bob? Say it again.
What? So, but it's like the process matters. And the reason I became so adamant about covering this case and reading everything by both sides that was put out there was because it was clear to me and every other defense attorney in this country that was keeping an eye on this trial that shit was gone, had gone awry, that it had run, the train was off the tracks.
Excuse
Like
me.
that's when you see amicus briefs get filed, when you see attorneys from all over saying, I'm going to throw my hat in the ring on the arm pro bono because something's fucked up here. Like the defense community, unlike the prosecutors, they're all independent. The defense community is a very, very close, tight-knit bunch of folks. And I'm talking nationally. It's not just like state by state, or it's like defense attorneys, because we understand what we're up against in terms of the power and the resources of the state. We are the perpetual underdog, always. So, I get defensive about it because, people misconstrue what we do. And, and I spend a massive amount of time trying to educate people what we really do. And I think I've made headway. And I made so much headway that I made enemies.
I agree. I mean, I coming into this as somebody new, I mean, if you type Delphi in, the just a couple come up, and it's helped me learn a lot listening to the various creators, including you. But I just had one other question in relation to just the contempt hearing.
Yeah.
And T and Sleuthy and Dan, I don't want to misrepresent anybody's opinion of this. I'm just saying my opinion from reading through this. I did feel like Hennessy did a good job, even though there's two people out there who said he was super sloppy and whatnot. And it is interesting to me.
Say it again, Seagull. Say it again.
Here, let me move closer to the mic and improve my speech. It is interesting just as a YouTube creator. I don't even know what the hell that means anymore. But when you've got these low-level creators, people with just a couple thousand subscribers that did have, I saw Fig Solve say what he said on the date he said it. And it was not when the PCA was out. So it isn't, how the hell do these, and I don't want to dox anybody, but I don't think he's even on this half of the country. You know what I mean? Like, how are these people that are nowhere near where the epicenter is getting this information? It leads me to some questions. So I'm just curious, when it comes to this unclean hands doctrine, was the purpose of Hennessy showing, hey, the prosecution did this too? Was that to, I don't know, get them to withdraw their motion, or was that for the judge to have to hold them in contempt too?
No,
I mean, for the public?
I know exactly what you're saying, and unclean hands just doesn't apply here. You know what I'm saying? Like it's a great doctrine, and that's what Hennessy's point was. It's like the two wrongs don't make a right type thing, and the state was doing this shit beforehand. I
more or less thought that he was saying, like, Judge, you need to think about what it is that you're going to say and how you're going to determine consequences, because I'm trying to show you that then McClellan also is going to need, like, it has to apply to everybody. And I'm going to have now on the record a showing that he also did it. And so the consequences should apply to him as well.
And beyond that, what he showed is there was nothing that was willfully done. They provided zero evidence. There was the only thing that matters in a contempt hearing is that you have willfully violated a court order. Period. There, like any other explanation that anyone else you've heard that said it is wrong.
His witnesses.
If you listen to people that know what they're talking about, if you listen to Michael Oshbrook or myself and any other attorney, Kara Winnicky, they will tell you that contempt is willful conduct, not mistaken. Not somebody came and took pictures in my office and distributed it. Like him continuing to puke out that it was an ongoing leak without any evidence whatsoever was disgusting to me. He just kept saying it throughout that hearing. That was the one reason I was happy that you got this, T, because I thought that was so disingenuous of him. Did you see, like, from a completely objective basis, did anybody see any evidence whatsoever that they made a connection between Baldwin intentionally asking for these things to be leaked, because that's what the implication was.
Bob, I
Absolutely
think,
not.
No,
I
not at
think-
all.
Right,
I
because it
think you'll
wasn't any.
find that you have people on the internet trying to act like they have sources they don't, and that's what I think I said in the studio chat was, you have a guy pretending to be a lawyer, then acting like he's in contact with people, and really he just basically had a source that knew the people, and that's all the evidence they have. Some braggadocious guy on the internet saying, "Oh, look, I'm a lawyer and I talk to them and they give me information and I have the crime scene photos." I figured there might be more, but that seems to be it. And it was screenshots, not even messages.
They
And
never even had any
also,
downloads of the actual contents of these phones to prove anything. They just kept saying it, which was the most frustrating thing to me yesterday when we were reading it. Was Nick just kept saying like these ongoing leaks, and even when like Holeman was testifying, he testifies saying, "Oh yeah, he says Andy all the time," and then when Hennessy crosses him, he's like, "Okay, well, where does he say Andy?" And he's like, "Here, this one point where he says, Andy," and he's like, "Okay, well, where's the other ones?" He's like, "Oh, I don't know what we did. I don't think we talked about those," and I'm like, "Well, isn't that the whole point? Like that you're literally testifying that Fortson had communications directly with Baldwin, and yet there's nothing showing that is true."
Right,
But here
no
you guys
proof.
are continuously saying it over and over again,
Bold
which
assertions
doesn't make
in
it
a
fact.
court of law. Like,
Yeah.
and Nick
Yeah.
McClelland is called Brad Rozzi and Andy Baldwin liars just one
They
too many
accuse
times for
the
my
defense
liking.
of-
And what is that called? When he's literally calls it an ongoing leak and makes these insinuations that Baldwin is communicating either directly with Fortson or whoever, and that this is an ongoing leak, yet doesn't substantiate it with anything. And I'm going to tell you, and it's a move by the prosecution to continue to destroy the credibility of Richard Allen's defense lawyers.
Mhm.
Absolutely.
I'm telling you flat
Well,
out,
Bob,
they
look
did the
at
same
yourself.
shit to us when
You're
they
having the same thing
booted
happen now.
Allison. Huh?
You're having the same thing happen to you right now. I
Well,
mean,
I
for
don't
the
give a shit.
record,
My
no,
content speaks for itself.
no, I know. I'm
You know
saying
what I
well,
mean?
like
the
you're
thing with
literally,
this,
they're saying that you're colluding with the defense, which you're not even part of it.
and the problem
Obviously,
with
I'm
this
not
is that
licensed in
Yeah,
Indiana.
no, exactly.
the problem with this is that all the exhibits are sealed. So the fact that people can't see what they say is what they're using to continue their argument. Like, well, we couldn't see, but if we could, it would show that he purposely was sending him stuff, And now, having read this, after having read McClelland's response to the memo for after the hearing, and he made that comment about how that the evidence showed that Baldwin was specifically feeding them information for them to take to the public to gauge the public's response. Having now read what was actually said was that Fortson was trying to get the public's response. Like, how can you attribute Andy's intent? Like,
Ugh.
at
Like,
the very most, you can say
I
that Fortson wanted to know.
I
You know
can't
what I
even
mean?
entertain that argument because it's
I know.
absurd. Because you know what did that was the memo, the Frank's memo. You don't need pictures when he's giving detailed descriptions of the crime scene. What do you need the picture? Like, that argument has absolutely no merit. It's absurd. They put out a 136-page memo where they laid out their entire theory of defense. Like, any kind of ridiculous argument that they then wanted to bolster a 136-page memo by putting pictures that only serve to incite and anger the public is beyond ridiculous. There's no rational thinker that could honestly think that if anybody is ever, like, you ask any defense attorney if they ever want, like, we're constantly argue to keep those pictures out of evidence at trial. It's not the opposite. Like, you don't want pictures of young girl victims out to the world from the perspective, like, in general, obviously, but in terms of the case itself, ever. We're always trying to keep those limited as much as possible. They have to get enough in so that they can make their proof of death and get that proved up, but beyond that, you don't want it out there because it does not help you as a defense lawyer.
Well, I've heard you say that a lot, Bob, and I think I think your reasoning is pretty sound on you not wanting it out there and why you wouldn't want it out there. It does not help you. However, and please anybody chime in if I'm wrong. That was a lot of reading, but I know you don't have to have motive in a criminal case. You just have to prove it happened. But I'm just relating this to the contempt hearing. You know, they want you to believe Andy willfully did it, but I don't remember even seeing, was there even any reason as to why? Did we ever
No,
read through that? Like why
no.
would he willfully have done it? Maybe that would have helped people understand, but
Well, motive
I
doesn't
just
matter
need to
then.
hear
It's
an
what Sleuthy
educated.
just said. It's what Sleuthy just said. That she
Yeah.
just said that they insinuated that it was to get the temperature of the public of the theory of the case.
And that's just
Like
such a
that,
crazy
right? But like, but then
argument.
what the reality was is it was Fortson wanted to see how that would be accepted by the public if they would buy once they saw the pictures, if they would finally be like, oh well, you know, the satanic panic thing, maybe there's something to it. You know, it's like it clearly had nothing. Like my point being that the memo in and of itself spoke volumes. You
Well,
know,
that's
you
not to
don't
say
need
that
to put out
Fortson or
photographs.
Westerman or any of these internet people didn't have a motive doing the same thing, like they personally wanted to get involved. You see it all the time. People in the YouTube and they want to get involved in the case. But that's
Right, it's
not to
clout
say the
grabs.
defense yeah, exactly. And the defense
That's what
lawyers
it
aren't
is.
doing that. You keep hearing them people say they're going to get a book deal out of it. I think their career's been their whole career's been tarnished over this case. And I don't think people understand that.
They're already
Right. Well,
accomplished.
that's a great point, man, because that's what I'm my bigger point is that Nick McClelland's motive in terms of deciding to take whatever amount of time away from his trial prep and focus on this was to tarnish the reputation of defense counsel going into this trial with
Mhm.
the potential jurors. I mean, dude, like if people don't think that that's a real thing, you know, that has an effect on potential jurors if they become aware, oh god, these lawyers allowed for this leak or they caused this leak to happen, and
Okay,
they're scumbags. We can't trust
I
the
want to
thing that
interrupt
they're saying. Yeah.
Mr. Rozzi, because this is exactly when I was asking you that question earlier. What was the purpose of him doing this? And that's exactly what I was thinking was, is he trying to get the ruling on this before a jury is picked so he can taint a jury pool that these guys are just, look at all the shady
Full of
stuff that
shit.
they've done?
They don't even need a ruling. You
Yeah.
know what I'm saying? Like
Right.
what happened when they did this to Allison in Omaha. All right. So it was like, and I'm actually just up to this episode. It was their star witness, their material witness, who was an exotic dancer who had claimed that Anthony Garcia, like in one of their drunken, like lap dance, private dance things, confessed and said that I killed an old lady and a young boy. So she then becomes their star witness. We send our PI out to interview her. Thankfully, he of course recorded all of it. And in that initial conversation, she walks it back. I would not consider it to be a full recantation. And the fact that she was just saying, look, I can't, I wouldn't trust anything. I was on meth. I was drinking daily. Like I wouldn't trust anything that I said or heard back then, so like, I'm not like, I didn't actively lie. I didn't make this up, at least, but I can't trust what I may have heard at that point. So it was like, so Allison and follows that up with a conversation that night. And then she contacts the state. It would be like them calling McClelland, and McClelland would say, oh man, he's like, I want you to go to the Indiana State Police. Okay, which is where she went because she was living in Terre Haute. And then they interviewed her. And then I'm literally in a deposition of their medical examiner with my father. And I get a phone call from the press saying, oh, Bob, do you have any comment, or does Allison have any comment on the motion for sanctions against Allison for harassing and intimidating a material witness that they put out? So they literally sent it to the press before I was even served a copy of it. And that is, of course, on the front page of the paper leading into this trial. And like, if you don't think, and we had lost our motion for change of venue, unbelievably, even though they tried this guy in the press for 3 years, same conditions, 23 hours a day. Look at the picture of him at his death sentence
He
hearing.
looks
Like,
horrendous.
he looks like Ted Kaczynski, except sleeping.
He's like
It's
drooling.
it's insane.
Mhm.
You know, so that, like, and I bring up that case because, like, I was telling, you know, Kara, and I told, you know, Michael and everybody that I talked to on the defense side of this, I'm like, look, this thing is so similar in so many respects because the state will do whatever they need to do. They've invested a huge amount of money, time, and reputation on getting this conviction. Those are facts. They can ill afford to have this thing blow up. They can ill afford to have this guy walk. And they're doing everything in their power. I mean, like, I like, dirty pool is not a new thing. You know, like, it's just not. A judge denying defense motions almost on a loop is not a new thing. We lose a vast majority of our motion work. That's just facts. Unless you have a blatant, like, just crystal clear violation of the Fourth Amendment on a suppression like motion or a motion to quash, you're typically not going to prevail on them. So
But
I'm not
are
even
you denied
threatening
without a
them.
hearing?
No, but no, like, we always have hearings. You know what I mean? It's
Okay.
like that's if I filed a suppression motion, I get to put the cop on the stand. You know what I mean? Because they understand that it has to be done for the appellate courts to have a record of what the hell went on down there. That's all they have are the transcripts. You know what I mean? There is nothing else. They don't go and watch or read, you know, from the media or newspaper articles. All they have is the record, which is all the transcripts from all pretrial hearings. And when she's not conducting hearings, I mean, legal argument, she doesn't need a hearing. Like, they've reduced it to writing. They've made their arguments there. And, you know, but would it be nice if she gave a thoughtful opinion and ruling based on findings of fact and stating what laws she's relying on and denying it? Yeah. And not for me and not for the public, but for the appellate court. They need to know, because if you start reading appeals, which I highly recommend anybody who enjoys you know, this kind of stuff, like trials, start reading some appeals, because you really start to get an understanding how the law operates and how it works and how important precedent is.
Bob, maybe you can lend credence to that too. Travis,
Who are those
on
two sweet
CJ's
little
show.
pups?
Well, we got Motley from Motley Crew, and then Ellie.
Nice. Love it.
Travis said they teach judges to not leave anything on the record and do exactly what she's doing, so that there's no, like, it's ambiguous.
Yeah, I mean, Travis put it up. The easiest way to put it is motion work is how we speak to the judge. You understand? Like I can't call a judge up and say, "Hey, judge, you know what? I was just reading through this police report, and the cops really violated my guy's Fourth Amendment rights. The search was bullshit. They didn't have any PC." You know, like the way that we speak to the judge and to opposing counsel is by preparing written motions and putting them in writing, filing them with the clerk, serving them on the state, and then having a hearing. Typically, that is how we do it. And as Travis is so eloquently stating, we have an absolute duty to investigate on behalf of our clients. Like, if you have a case where you have issues that are at issue or facts that are at issue, you have an absolute duty. Like, we put our hands up as officers of the court and we swear to uphold the Constitution. And we is part and parcel of that. We have to investigate on behalf of our clients. They can't do it if they're in custody. I mean, like, if I have an out of custody client, I'm putting them to work typically. Like, if it looks like a case that's going to go to trial, I'm like, you need to get me, like, witnesses to talk to. You know what I'm saying? Like, let me do my investigation. That's why I have my PIs. I send them out. I have them do the interviews. It's like, because you're getting a very one-sided version, a very tunnel visioned version of the state's facts when you're reading police reports. And like in states like mine, where I unfortunately cannot depose witnesses, I have no opportunity to talk to these people, but for if I send my PI out and they're willing to talk to them. And most of the time they're not. Most of the time they call the state, they'll be like, oh yeah, hold on. And they call the prosecutor and they're like, yeah, the defense guy is at my door. They cannot tell them not to speak with us, but they certainly can tell them that they don't have to speak with us. And that lets them know that they have no obligation to speak with us. And then they don't. That happens all the time, the vast majority of the time, way more than they do speak to us. So, you know, I mean, I'm ready for this thing to go to trial. I'm ready to see what they got. You know, it's going to be a banger. I'm just so sad. I'm so very sad that she's just adamant about not streaming it. I don't like once you have a jury and panel, there is no rational explanation because they're already going to be sequestered. These are Allen County folks. They're all going to be living in a hotel anyway. What is her rationale behind that?
It is sad that you're going to have to
live in Delphi. Yeah, it's miserable.
And I don't even know. I got to figure out, because my dad lives in Kokomo, which is a short drive away, but I got to figure out how, you know, whether it's a lottery or if I have to sign up or something of that nature, because I would love to go. But T, I had a quick question for you, and I'm going to put you on the spot on this one.
Okay.
As somebody who, you know, I think you said you know, reasonable stance on the fence, need to see more type of deal. But just let's take the filing talking about the prison conditions. Let's take the filing where we get the back and forth between Holeman and Richard Allen. And then let's take everything we just read here. I'm not necessarily asking you if this is pushing you in a direction of Richard Allen is innocent or guilty. I'm just asking you, is this instilling confidence in the state? Because I you know, my position is what it is. I've been pretty out front with it, but damn, man, this is not instilling confidence in Nick McClelland for me. It's just not. Especially
well, no,
what we just read.
For me, I think part of my major issue when the PCA came out, I didn't think it was the greatest PCA I had ever read, but I was like, okay, well, they've got their guy. They're going to continue to investigate and run. You know, they hadn't done all the testing of all the evidence that they'd gotten from his house. I was like, okay, they're on the right track. And I was like, I lean towards having faith in the system and that they're doing their job correctly and that they have the right guy. And then as time progressed and over the summer, when the hearing was happening in June, and then come August, you know, defense attorneys are asking for cameras in courtrooms. And then obviously come September, we get just the onslaught of the Franks information. And for me, I think that my lack of confidence in the system here, whether it be, because I still go back and forth on whether it's McClelland, and even though I don't like some of the things he says and does, if he's the one who's actually, like when we talk about like the Purdue professor, like Holeman knew who it was, but McClelland's sending this email to the defense attorney saying, we don't know. So is Holeman just not telling McClelland? And then like, is there like a side conversation? Like, what the fuck, Jerry? Like, why did you not tell me you knew this shit? And now I look like an asshole.
That way, T. I mean,
I hope so.
If
I don't know.
That out lying to them, like, you know, I mean, that he can get sanctioned by the disciplinary if he's flat out lying in a case. Like if he knew that they had found out who Turco was, you know, and like flat out lied to the defense counsel, then that's an issue,
right, Bob?
Is it just Holeman that's shady? Is it Liggett that's shady?
Well, Holeman literally, I think Holeman testified to the fact that he knew who it was and sent him a letter.
He did.
Yeah, I mean, he did do that.
Right, but the chain of events went that when they found out about the professor, when they got the discovery, and then like they sent the letter or they called Nick and like, who's this dude? Who is this guy? And Nick's like, okay, well, I'm working with Holeman. We're trying to figure it out. And then a couple days later, he sends an email, says, look, man, we can't figure it out. Sadly, we can't. With like, no one has any idea who. Like, and the reality is, if you go through, like, I jumped on Purdue's website and went to their, you know, like anthropology, just went through the different departments. Like, you're talking about like 3 professors in entire departments like that. You know, this isn't rocket science. It was like, it was so like just blatantly bullshit, you know, and it's like, and I don't know what Turco says. I can't wait for Turco to get on the stand and just hear what this dude's like them having a pissing match in terms of them trying to interpret what he said in these interviews is insane. You know, it's like I want to get Turco on the stand and hear what he said. I'm so tired of hearing that argument. You know, it's like, again, everything, you can have the same exact set of facts and you can have two different sides completely interpret them the exact same thing. And that goes to words as well. I mean, things when you're reading written words can be misconstrued or taken out of context massively. You know what I mean? So
there's no tone or tenor.
There's no tone or tenor. I mean, those are my the two T's that I'm always talking about. Like if I'm in an argument with Allison, I'm like, dude, I'm not doing this via text. Like you want to argue with me, call me. It's like you can't, like, we can't argue or with anybody, any kind of bickering, any kind of like dispute, you cannot do via text message unless you want to just have a bunch of shit misconstrued, you know? Yeah, Sierra, I don't know how they're going to work the trial. Like, I hope and I don't hope that they do it kind of like they did it with Chad Daybell's in Idaho. They had a lottery system. I don't necessarily like, I like the concept that I don't have to get up at the crack of dawn to sit in line like I do for every other hearing out there. You know, but I also don't like the fact that I think that Gull will probably boot me out. I should be like, oh, that motherfucker, he's gone. Make sure that dude's name is not in the in the fishbowl to get his name picked, you know.
I mean, I don't know how she's going to do it. I hope that she does some type of lottery, but I mean, she probably won't. She'll probably just be like, I don't care if you want to come to the trial and there's only 30 seats, then you're going to stand in line from 3 a.m. And that's the life you've chosen, because she just doesn't give a shit.
Right.
So, but CJ, to answer your question, honestly, for me, I think that I'm here on the fence because of these types of things. I wasn't on the fence. I had faith that they were going to do the right thing. And now I don't, but it doesn't mean, and I said this yesterday, it doesn't mean that I don't think that he's potentially the right guy. I have two very big concerns in the fuck ups and the crazy bullshit and waste of time. Does that make it so that we have a child killer walking the streets because he's now free? Or does it mean that,
I mean, like, can any of you say, and there's one answer to this question, and CJ, I know I've been on a couple of lives with you and you like to ask this question, that there's only one correct answer in terms of innocence or guilt prior to trial. And it's, I don't fucking know. And he's presumed innocent.
Yeah.
None of us know. Right. Like, I don't know. I have no idea if he's innocent or guilty. But all I know is I've seen a PCA, and that PCA reads weak to me. That's all I base my opinion on. Like, it's mere presence. Mere presence in the law is not enough. It's just a famous kind of like just axiom in the law that like mere presence is not enough. You have to have more. So they're relying on this unspent round.
That's a great point you make, Bob. With like, I agree. None of us know. But I do think you can. I think you can have two things here, right? Like, you can say, I don't know, but you can also say, damn, these guys that are supposed to be helping me know are shitting their pants. And sorry for putting it that way, but one of the things I've kept saying is like, I didn't get to where I'm at because I put myself here. I got put where I'm at by watching the actions of the people that are supposed to be the professionals continuing to just crap the bed.
Well, here, look, man, out of the entire, like I sit here today still having no idea why Andy filed that second motion to suppress of straight denials. I mean, everything I understand there's people out there misconstruing shit, but anybody that can understand context at all understands that when Rick Allen's saying, oh, when a good guy kills two girls, like that's not an admission. Only a moron would think that that's an admission. This is a guy who's been accusing him now for a second interview for hours that he's a murderer. But then he's turning around and saying, I don't think you're a bad guy. And it's Rick saying, oh, really? And, but good guys don't kill two girls. So I know you're full of shit.
Right.
I mean, like, that's
anybody who thinks
the
that
most telling thing to me in that entire thing and it should be very unsettling to everybody that is relying on the fact that they got the right guy, is the fact that we know without question, when they called Alan, Kathy, and Rick to come and get the car, that he was getting arrested. He was never leaving that police station that day. That came from down on high. I guarantee you that this is not just Holeman sitting in West Lafayette alone. Like, you have Carter, you have Liggett, you have everybody on the Unified Command that wanted to be there to watch this thing go down in that room on the other side of that double-sided glass, watching it happen. And he was never leaving that room. And when Holeman's last words are, "I know you did something and I'm going to fucking prove it," knowing that they're arresting him that day, that should not give you the warm and fuzzies.
Mm-mm.
Okay. That does not sound like somebody who's got them nailed to the wall. That sounds like somebody who thinks that maybe they have enough to go and get the arrest warrant, but we're going to find what we need to in our post-arrest investigation. We're
That's
that
right.
confident you're the guy. And maybe
Otherwise,
they
he would have
did.
said, "We can prove it. We can prove it. Here's all the
Right, we
reasons."
got you, sucker. You're
Yeah.
done.
Yep.
You're done. We got you. You know, and it's like that was because that was the last thing he says to him. It was extremely telling to me. Extremely. You know, and it's like, I think, because I honestly think that the real motivation for getting that out there was for the public to see that from the get, Rick Allen has been denying this shit. From the get, from the first time they talked to him, hard pushback. Like, I don't know what the fuck you're talking about. Like you're reading it in words, but you can tell that's a heated exchange between two men. And in the first interview, when he comes at him and he's like, you know, I'm not going to be somebody's fall guy here. I'm not going to be somebody's fucking patsy, dude. You know, it's like, you know, and he's coming at him with that shit. It's like the pushback was immediate. Like, those are flat out denials. You know, that did not smell like a guy who, like, that's the kind of shit where if it's a guy who's done it, that's like hardened criminal shit coming back at a cop like that. Rick Allen's never had interactions with law enforcement before, ever. So he is not seasoned of sitting in a room with investigators and being comfortable enough in his position and his innocence in his mind to push back like that. You know what I mean? You usually see the stammering and the stuttering. I mean, T, how many like investigative, like, confrontations and interrogations have you watched in your years of doing YouTube?
A lot.
You see when people are starting to crumble.
Oh,
you
yeah.
can see it. You can sense it. You can tell when they're fucking lying. You know, like, I just, like, without having the benefit of seeing that video, just reading the words, I could feel the pushback there. That would be like the kind of shit that an innocent person, like, what the fuck are you talking about? You can fuck with me, but don't fuck with my wife. You know, all that shit. You know, I don't know. I'm beyond done talking about like, and I never talk about the facts because I don't know them.
No,
But I'm
Bob,
beyond. I'm ready for this thing to go to trial, bros.
Are
And
you
sisters.
aware that, like, the locals in the jury pool have no idea that any of this is going on?
I don't know. I mean, we can only hope.
I live less than a half hour away from Allen County, and I watch the local news at home, and they literally just, there's blips, and the amount of detail
perfect.
that we all get into, they have no idea. I talk to people from Fort Wayne all the time. They don't care. They're like, well, there's a trial going on. And
I know.
people think
I love that. Dan, I said that on
everybody's
one of my
swaying
lives.
the jury.
I said, like, I made that exact point. I told people, I'm like, look, if you think, like, I feel very confident they're going to be able to impanel a fair and impartial jury up there. I do, because of exactly what you just said. I challenged people that were in the lives that live in Allen County or Fort Wayne. I said, hey, like, just do a little sociological test. Do your own survey or your own poll. Just ask 10 random people of all different ages. Talk to some millennials. Talk to a couple 70-year-old couple, like, eating dinner on a nice little, you know, patio out at lunch, and say, hey, you know, you heard anything about that case with the two girls? Right. They're not. No one's going to have any idea.
And I say that if anybody in the chat wants to know, News Channel 15, I think, on YouTube, all they do is cover the, like, blips that there's a hearing, the defense did this, that, and that. There's no, like, this whole big discussion everybody has on both sides. None of these people know that unless you're obsessed with the case.
Exactly, which is a very small universe of people.
Yeah,
Like,
you're
even-
talking
even
what's
it-
the
like-
biggest
like-
YouTuber on this? 30,000 subscribers or something, you know?
Yeah, and it's like, you
There's
know,
no
and mine
100,000
do
or
pretty
million.
well. Like, I think my message gets out there, at least in terms of, you know, I'm like, because my message is you got to wait. You know, like everybody has to wait. We have to wait for trial. Like anybody who misconstrues me for saying that I think that somebody's listening before trial knows nothing about me or my content or what I'm
I think
about.
the biggest
Like
thing
that, like
I've
I
heard
could
from
not be
people
more
is
clear.
the fact that there's no evidence, because people don't know. They just know a guy got arrested, and then they're flabbergasted to hear the lack of evidence or anything that's been released, even if they try to look into it.
Yeah, Julie, I've definitely got a potty mouth, and I don't apologize for it. That's just how I speak.
That's how I
Like
speak.
I spent 20
don't
years
even
in the
hear it.
courtroom, never saying a foul word, and you know, it's like I'm not in court anymore, so I get to let my freak flag fly. So that's what I do. You know, we're all grown ups, and them's just words. Like my thing with swear words is like, who determined that shit was a bad word way back when? Like some dude, like some guy said, well, that's shit. And then somebody declared that was like that is a terrible word. I've never heard it before, but it sounds gross and I don't understand who determined way back when. And I've like from the etymology of words, I've tried to figure this out because it's like one of those things, like when I eat an edible, which are legal in Illinois, by the way, you know, like I get in these like weird, I'm like who decided like what words are foul words? Like, honestly, like I don't know. It's always been a weird thing for me. So sorry, Julie, if my like earmuffs, I'll give earmuff warnings.
I gotta make it.
And I talk just like that, so she's used to it.
I mean,
I need to make a thing onto an intro that gives you a 30-second head start that says "Get the kids out of the room" because we just don't know. But I had another question too. There's just something I thought was interesting, and obviously not being an attorney, but Sleuthy and T, you know, you guys have read through so many of these transcripts and filings and things of that nature, and this is just my opinion. So, you know, please push back on me if I'm wrong. But you know, recently, at least recently, it feels like the defense is saying this happened and we have receipts. And then when you look at the state's filing, it's just either, okay, like I'll use the geofencing, for example. Well, the state just doesn't know. The state just doesn't understand. Or I'm sorry, the defense. The defense just doesn't know. The defense doesn't understand. Or the defense is lying. And it's interesting that there is a considerable number of people that really believe that. And then they say, well, I'm not going to take anything that the defense says anymore because they're just full of shit and they're liars. But I've never seen a state filing backed up with anything other than their words. So it's just astonishing to me that we've
and
gotten
it all
to this
pans out
place.
after the motion too, like the whole prison guard thing. They tell them, you know, they basically throw a fit about it, and then you find out, oh yeah, they are.
CJ, like I'm assuming you watch my content, right, dude? Like I read every filing. Like, and you're hearing from two actual defense attorneys. Like Allison's evaluation of McClelland, or it had to, like, I don't know if it was Luttrell who fired back on the geofencing thing, was so spot on, because what that means in terms of Carroll County and that prosecutor's office is that they're never going to be able to use that type of technology to get a conviction, because they flat out say in their own response that it's unreliable.
But why is that though, Bob?
Do you understand that though?
I understand what you're saying, but
I'm just
curious.
But that's a huge thing that prosecutions use these days to get convictions. Like the Murdoch case, that entirely rested on two things: one, the death by financial crimes, and then the phone. The phone is what it created the time of death for them. It created the timeline of all of his movements. Like everything was the phone for them. So Carroll County effectively moving forward in any other criminal prosecution, if I'm a defense attorney there and I'm going against Nick McClelland and they're trying to come at me with some geofencing bullshit or some triangulation from a tower, I'm saying, hey, Nick, remember that one motion you guys wrote about how it's unreliable. Well, why is it reliable now?
Yeah, that's a very good point, Bob. And that's what the geofencing, but I'm just curious, Bob, from your standpoint, like, okay, even take Turco into it. It just seems like the state says, F the defense, they're liars. Like, is this just because the defense got shit on so hard because of the leaks? Or,
CJ, I have never in my professional career seen a prosecutor defame defense attorneys like this. Like, call it, like, it's one thing to interpret things differently and say that they're incorrect. Lying is where you are purposefully telling an untruth, which is a fraud on the court. It's like if I were, like, any time that we ever attack the integrity of law enforcement in a court of law, the judge just loses their shit on us. You better be able to back this shit up. This cop's been testifying in my courtroom for 15 years, that kind of shit. And they're like, and if you're not going to be able to back it up, I'm reporting you to the ARDC and you're going to explain it to then that type of shit. And we say we can back it up, and it's like, so I've never seen it before, CJ, honestly. I see pushback. You're always going to get the opposite side, from the prosecution and the state in terms of defense filings and vice versa. I mean, that's what the law is about. You're interpreting the same things differently. But to flat out come out and call people liars, officers of the court, and look, prosecutors and defense attorneys they swear to the exact same oath. Exact same oath. All of us do. We go in, we put our hands up, and we swear to defend the principles of the Constitution. Like, we all take the same oath, So it's like it's like,
just interesting that you see.
It's blown me away.
So for example, the in the filing over the prison conditions, and you see the claim made that they're altering his medication or the dosage, and my God, that was. Like saying the earth is flat. They better be able to back it up, or else they're going to get lawsuits because these are doctors that have worked in the prison for so long. And it's like, look, man, I simply don't know. I don't know. And I would be willing to believe, unless I'm just supposed to believe, that Brad and Rozzi are complete dumbasses and are willing to throw everything away for this. If I'm not willing to believe that, then I'm going to give them the benefit of the doubt. However, I've seen a lot of things claimed in the state's filings as well that are also not backed up, but you don't hear the same pushback to those as you do. What I mean?
Okay, let me chime in real quick, Bob. I just want to say something real quick. There has been, and since CJ, I know you weren't around on the YouTube streets for a while, there has been a very clear narrative that has been overwhelming on social media. There has not been, since Richard Allen was arrested, there was not there wasn't groups that were forming saying Richard Allen is innocent. Like, that was not a big thing. There was nobody talking about that this wasn't the right guy. People just weren't doing it. Everybody was either kind of silently just waiting, kind of like me, or they were talking shit about Richard Allen, and what he did to the girls. That was what was happening until the last 6 months. This is why you see so many people pissed in their feelings that there is a Bob Mata or an Ali Mata or anybody, or an Unraveling, or anybody pushing against this narrative that has been the main focus of the entire time since Richard Allen has been arrested. That they do not want the opposition, and they don't know how to fight the opposition because they have never had to do it.
Right.
And so instead of actually fighting it, they try to be like, oh, look at Bob. He works with the defense. He's a defense shill. Or to me, even, and I'm on the fence, they're like, people come in and tell me I get paid by the defense team. I'm like, well, shit, where's my damn check?
That's what they don't even get paid.
They literally said that I was getting paid and that I'm a part of the, like, and like, talk about being on the fence. Like, again, my content is all online around my podcast, and it's like unequivocal. Like talking about being on the fence, that's in my entire thing, is everyone needs to fucking wait until trial. No one knows shit. The only people who know anything are the prosecutor, the defense attorneys, and the defendant. That's right. The only people who know the evidence. None of us.
Yeah, and they're still just interpreting it anyway. It's not like
it's a theory.
So
exactly.
But while we're talking about money, I just want to say, because I saw like several people mention the fundraiser. So Stripe, which is how Pay It To pays people when they request their money or whatever, they updated their terms of service like in April this month. And they sent a letter or an email or something to Hennessy saying that now you can't fundraise. There was many things like they don't support crowdfunding anymore. There was a couple things. It's unclear exactly what it was, but anyway, they said that he could keep the money that they've already raised, but they can't raise any more money. So that particular fundraiser is not going to be back up. I don't know yet if they're going to try to open up a new one.
That
So
place
there's we're not like waiting.
They don't offer another way to pay out like besides Stripe. That's the only thing they offer.
Yep.
Oh.
Like the last time that something was wrong, I tried to log in because I was trying to figure out like if maybe he used different logins and maybe that was what made them think something was weird and he had to send all this extra shit in. But like when you sign up for Pay It To, you have to, if you don't have Stripe, you have to get Stripe and you have to do it before you can even create your fundraiser. So he created his fundraiser or he created his Stripe account and then the fundraiser, and that's how it's been going. But now that they've changed their terms of service, it's no longer under the terms of service. And they don't say, well, you can replace it with a whatever, a PayPal or whatever.
Right. That would be the easiest thing, no?
No, they don't. They won't. Stripe or Pay It To, they only work with Stripe. And it's probably legal. It's probably some kind of contract thing. Like they probably had a contract with them and they don't have a contract with anybody else. So they would have to do all that. I don't know if he's going to say that he wants to like go for the extra 5,000 to get to the goal using a different platform. I've thrown a couple out there, but I just don't know yet. But he'll get to keep what's been sent already. Yes,
Gotcha.
Bobby.
That's good to know because, man, we could have done some numbers Friday night, brother. I'll tell you, I really think we could have, but we'll figure something out here. We'll figure something out.
Burning at both ends.
I mean, to be honest, Theo, I'm still hoping that Gull's going to give them money as well. You know, I mean, it's like,
well, for sure.
To me, like the bigger goal of the fundraiser was that Gull became aware of it and felt like some type of shame or something of that nature to be like, all right, like I've got to like, you know, I mean, to me, everything is just making people aware of what's going on. Like that's what I've been doing for months with this case is just making people aware of what's going on, making people understand that all of us as citizens of this country have rights under the law, under the Constitution, and we have to care about each and every individual, including every defendant in every case. You know, and this case just happens to have enough, you know, people following it to where it's impactful to be able to get it out there. And T, to go exactly to what your point is, and I don't know if you saw my lives for the past couple weeks, but like as soon as the thing came out about, because what I've been saying, that when you look at the two most toxic communities in the true crime community out there right now, it's the Karen Reed case and it's this case. And, and the thing that they have in common, which is incredibly uncommon, is the fact in both cases, the defense, total theory of defense has been laid out for the public. You just don't see that. You typically only have either the state's theory by way of when they're indicting him and they put out their version if he was indicted by a grand jury and then he's getting arraigned and they're giving the formal charges. I usually I waive formal reading so they don't read all the factual basis of the charges. You know, I just have them read the charges themselves. And, you know, or you have a PCA, you know, if it was done, that way. And in terms of the state having their theory out, we're so accustomed as a society of only having the state's theory of the case out there, which in these cases takes typically, if there's not a speedy demand, 2 to 3 years to get to trial. And that's all the media reports on is the state's theory of the case. So like for me as a defense attorney, I loved it. I was like, oh my God, like I talk about it all the time, that balancing of the scales of justice. Now you've got two theories out, but you see what it does is it creates the divide, because now people are hearing the defense's theory, and it's all it is. Like, I have no idea whether any of what the defense is saying in their memo is going to hold water, if it's going to hold up at trial. That's why we have the trial.
Don't you think it's really interesting, though, that the PCA comes out and that you don't see like a giant uproar of anything, which is
that's what we're accustomed to, T. Like that's how it's always been.
Theory of the case. But then as soon as the Franks memo comes out, it's like fucking fireworks everywhere and people are losing their shit.
It's because it's new. That's what I'm saying. Like it's like it. I cannot think of another case, and Michael's in the chat as well. Michael, I cannot think of another case other than these two where I have heard the defense's theory come out full bore, other than Reed and in this case. I've never seen it done before.
Scott Peterson. I'm trying to think of it when it came out, like how far before trial it came out. It was years ago. So
I mean, like his was his was just like a general denial. You know what I mean? Like we have like in both these cases, the difference is that they have alternate suspects. You know, in Reed, they have alternate suspects. Here, they have alternate suspects. In Peterson, there was no alternate suspect. Not really. Not that they put out prior to trial.
That's how I was trying to remember if it was prior or not. I can't remember.
I don't think so. Like it was just like, it was kind of like what, it was like alibi type shit. Like the thing that we're seeing with, with Koberger. And like, look, like I disagreed with Sleuthy on the Koberger thing. I think that she didn't think that the PCA and that was quite as strong as I thought that it was. I'm not discounting, because I understand the power of a sheath with his DNA that's unequivocally his. How it got there, I have no idea. And that's what the defense will focus on, and trying to say, well, you can't, like, it's a bad look. It's a very bad, like, I don't want that fact in any of my cases ever, that the sheath that fits the knife that they are going to claim caused all the injuries and all the deaths in that house appears to have the DNA of the defendant on it unequivocally. And they're not going to be using the IgG. They're not using the dad's DNA. They've gotten his profile, and it's his. So, like, I don't want that for my defendant ever in any case. It does not sit well with the jury, because
I have to ask your opinion,
Bob. You know what I mean? And like Huerman, and again, and I say these things still under the precipice of, look, I have to wait till trial. Could I be convinced that he's innocent? Yes. If his actual alibi holds water, like if they can prove it up.
I was just going to ask you about this alibi. What do you think of this new alibi?
I don't know. I think that he was smart. I think if I were him, I would have dropped my phone off in that area 2 hours ahead of time, left it there, and came back and picked it up. That's what I would have done.
Hey, T, can I ask just one quick question real quick?
Yeah.
Bob, this is for you. Just a real quick one in relation to the fundraiser, just because there was a lot of questions about it. In the sense of Gall giving them money, so this is a two-part question. One, is there a cutoff by hey, if she don't give them money by this date, then we're relying solely on the funds from the fundraiser?
I mean, there's a cutoff, and it's called trial. You know what I mean? Like, you have to be able to,
you can't approve it 3 days before trial, where they won't have any time to then figure out how to get their experts there and get them places to stay. And I feel like it has to be reason. There's a motion for parity and resources that's been sitting for over a month at this point.
And it's the pushback I heard on that was oh, there's no, they didn't do all the things that they're supposed to do. And that, no, those were filed. The motions asking for the money were filed under seal. Okay. And they were filed in terms of, they were supposed to be under seal, and they were not supposed to be seen by Nick McClelland, because again, really what the point of it is that, and Luke, I'm seeing you, like, I don't think you're getting my point, dude. No, like the theory of defense, I'm talking generally speaking, that defenses typically don't put their theory of defense out into the public sphere in high profile cases ever. I've never seen it before, except in those two cases. And this was like, believe me, when the memo dropped in this case, everybody was reporting on it. Everybody, like Court TV, CNN, everybody, like everyone was talking about it. But like now I agree with you. It is an echo chamber, and it's like, it's ridiculous because why argue about it? Because none of us know until it gets vetted at trial. Like, so from that, I agree completely. Like, I just think if you watch my lives, I'm never trying to figure out the case because I don't have the evidence. You know what I mean? It's like, I know what the two theories are out there, but I haven't hired experts. I haven't been able to parse every word of every statement by people. Like, I don't know. Like that's the entire point of the trial. Like, none of us know. Like
question.
Like I just see so many creators like sitting there, like superimposing Alan's face on the bridge guy thing. And I'm like, what in the fuck?
Well, that is a,
so weird.
I like to do a parody of a certain guy that does that from time to time. But I just got one more quick question for you, Bob, on the fundraiser. So let's say the judge does give them money. Will that money from the fundraiser, I mean, will they still use that money from the fundraiser maybe to get better experts, or do you think it'll just get shot back to everybody?
And I've heard you say, like, I don't necessarily think you're getting middle of the road experts. It's like you can get, because I mean, the fact of the matter, no one's oblivious to the fact that this is a high profile case, including experts, so you might be able to get discounts on what would otherwise be, a high dollar expert, and like, I don't know of many experts out there that are like, I need $50,000 because my word is like solid gold paved streets. And whenever, I mean, there's no dudes like
That's probably Coffindoffer.
Right. Oh, yeah. Wow. Yeah. Like that would be
Hey,
unbelievable.
Bob.
Yeah.
Is that stuff that I think or not Defense Diaries? That's you. Murder Sheet brought up about the invoicing. They said something about the judge was asking for invoicing, and he allowed them to hire a lawyer to do the invoicing. Like, if they're behind on invoicing, can that affect the people they're trying to hire being paid? Like, you as a defense lawyer, if you were behind on something like that, would a judge tell you, hey, you need to get this in check before I start throwing more money out? I need to see where it's going.
Well, yeah, but I mean, that's what I'm saying. Like, they have filed those motions. So like, typically the way that it goes. So from what I understand, the first couple of experts that they got like under the belt, they paid out of pocket. And from what I understand is that they were reimbursed. It was like 10 grand or something they put out. For
and I don't blame them either, because they were taken off the trial to begin with.
Well, you got to prepare. You got to, like, you can't sit around waiting, and it's like, and like Garcia, we had the same thing, but we had the family who was able to come up with some funds that we earmarked towards experts. We told them going into the trial, we're like, look, we're anticipating that it's going to probably be about 100,000 we're going to need for experts. So like, carve that out. Just know that it's coming. Like, be aware, because they were like mortgaging their house to like defend their kid, and it's like you feel terrible. So yeah, I mean, I think they'll absolutely be able to use it, CJ. I think they'll definitely be able to say, whatever goal, if she gives them more money, which I anticipate that she probably will, but like typically when we hire an expert, it's like, I'm going to get the CV. I'm going to find out what they charge. And that's what I'm sending. If they haven't done any work, there is nothing to invoice yet. They'll say, I need a $5,000 retainer up front for me going through the reports. And I need another, $2,500 to prepare a report. This is how much my travel expenses are. This is how much for court time.
So Bob, it's fair to say that we're moving on this road when it comes to the experts. Like, it's not something like, hey, we've been using the money. It's not something like on May the 10th, that's when we're going to start because we just hit the goal. Like, so we're already moving. They're okay.
Yeah. So yeah. And also those people misrepresented that whole, so the narrative that was getting put out is that the reason that she didn't give it, she would have gave them money, but she didn't give them money because they didn't do the invoices, and they know that that's what they have to do. So the narrative that was put out was that they basically went to her and said, we just need like all the funds. We need like all this money. But we're not really explaining why we need it or telling you exactly where it's going to go. We just want you to pay us now this huge sum of money for us to go get experts. And that's not the way that it works, but that's also not what they did. So they went and they found experts that they wanted. They used their money to pay these experts to retain them and to start working on the case. Once those experts started working on the case, they went back to Gull. They put in their invoices to get reimbursed for the amount of money, thousands of dollars that they had spent in order to retain those experts. She refunded them their money and then said, I'm not going to keep giving you money for these experts that you've already retained, who have already been working on the case. They're not trying to get like money for other experts because they don't like what their experts are saying. They're trying to keep the experts they've already paid money to get involved in this case and who are already familiar with it to come and testify at trial. Okay. So they've submitted the invoices. She knows exactly who these experts are. They've already been working with these experts. She's just denying it. Okay. That's literally all it comes down to.
That makes
And
more
I was
sense then.
asking Bob just for like, because just I listened to that the other day and I didn't understand how defense attorneys that are not being privately paid, how that works. And I don't know if you've ever done
these guys, if they're appointed,
work,
Dan, I mean, I think these guys are getting $100 an hour. So apparently Brad hasn't been paid in 7 months. I guess Andy got some money, but like, so no, they keep their hours and they submit it to the judge and she either approves it, and typically they do. I've never heard of a judge stiffing appointed counsel that are handling something. I mean, these guys have their own practices. These are like, I've said it a million times. These are like cases like this, Dan, are practice killers. You have to shut your entire practice
down. Right? I couldn't imagine. I wouldn't work for 7 months without getting paid.
Right?
I couldn't afford.
Well, and he's paying other people too. So like like Baldwin's getting paid, or he's gotten paid. Yeah, he's gotten paid.
He has staff that makes good money that are being paid to keep his practice open. I couldn't imagine.
And he's taking that money. So like he gets $100 an hour. He then has to take, so she's not going to pay the $15 or whatever an hour for the investigator anymore. So now he's taking that $15 from his $100 an hour. So now he's only making $75 an hour in order to keep paying the investigator that has been investigating for them, for the case.
That's the thing I bring up about people saying there's a book deal and all this. I don't know how much money people think that doing a press tour makes you, but it's not. I guarantee it's nothing like people think. Not near what a good defense attorney makes. There's no way.
Yeah, and I can also tell you this:
nobody reads books anymore either.
You don't get paid you don't get paid to do Datelines. You don't get paid to do 48 hours. You don't get paid to do any of that shit. I don't even get paid for being a talking head on Law and Crime or Court TV. No, and like I do a ton of free work. So I mean, like a book deal, it's a different thing. They could get an advance, on that if they're going to write a book. But in terms of like people that have a misconception of how much like attorneys or anybody makes, especially from like the hired help or appointed counsel side of things, that's not where the money's at. Like you see that the Huerman's wife got $1 million in order to for her life rights to do that documentary. Well, she happens to be the wife of an alleged serial killer, so like that's like, those are the type of people that get paid. Like anybody who thinks that people are making a fortune off this are nuts. It's like, it doesn't work that way. It's just, it's not the kind of money that people think. So,
it boggles my mind that people say that. And if you get a book deal, like I brought up earlier, nobody follows this case. Like all you have to do is look at all the YouTubers that only talk about that. Look at the subscriber count and the views. You're not going to find 100 million view videos. The Johnny Depp trial, it's nothing like that.
Right.
Or the Rittenhouse trial or anything
exactly.
else.
There's a very small universe of people. Right, dude. They're like Kohlberger definitely gets the most views. Like in terms of active cases right now, and like the shit that gets like 1 million+ views are like things with good
It's a niche
thumbnails that have like eye-catching things like about like interrogation videos. It's the shit that I'm always seeing that like crushes. It's like there's like a small universe of people that care about specific cases. You know what I mean? It's like Adelson has a pretty big following,
Well, and they were True
Kohlberger
Crime
has a
Daily
pretty big
for
following.
years on that Adelson thing. So it
Oh,
wasn't
yeah.
like True Crime Daily's been going off the walls for that since it happened.
Oh, for sure. And so does Surviving the Survivor. Like they were all over that. They had a lot of growth from that case. I mean, like I cover a ton of cases. Like I'm streaming Daybell. It's like people have this misconception that all I do is Delphi, and it's just not even remotely true. It's
No,
like
it's
my
just the only
my
thing that
passion
people in
project
this
is I'm
community
trying to
watch.
find additional Gacy victims, man. And like I get no traction on those videos. And I've got like an old Chicago cop that I'm working on. Like we're literally trying to unearth like additional Gacy victims. Like you would think that people would give a shit about that. Like that's actual victim advocacy, like boots on the ground shit. And it's like, I get like a pittance of what I get for Delphi coverage,
Well,
So,
and
but it's
Bob,
like,
your podcast regarding Gacy, man, that I started listening to it. That's how I found out about you. But I've shown a bunch of people that I work with.
thank you, man.
The Planet Evidence, dude, that blows
Crazy.
people's mind.
Crazy,
like,
dude.
And they're like, but the guy needed to go to jail, and we'll have a
No
discussion.
question.
It's like, yeah, but you can't do it that way. And they're like, well, and then you get them talking about it, and they're like, shit, there's no way. Like, what the hell? They're like, it blows people's mind, man. Yeah.
Thank you for spreading the word, brother. That means a lot to me. Truly, thank you for that. All right,
Tia, are we okay? We're going off the rails.
Scarlett from the mall. She's having a little boys and girls day at the mall. Like the little boyfriends were meeting them over there. So like little 12-year-olds wandering around the mall. That was like my shit back in the day. That's still alive and well, surprisingly. Did you guys used to have to go?
I'm surprised the mall's still open.
I know.
Like they're dying around here.
I mean, Amazon's really trying to kill them all, but it's like they're still like that. Like my view of malls is that women are always going to want to try on clothes.
Yes.
And like shoes and clothes for women will always survive Amazon because I think women definitively need to go see how something fits and how it looks.
Well, yeah, and Amazon lets you try it before you buy it now, so watch out. They'll let you order a bunch of stuff for free and then try it, and then your wife can just
but you still got to drive to like Kohl's if you want to return it. It's like a giant pain in the ass. It's like Allison's got more shit laying around this house that she's ordering on Amazon. She's like, "Oh, I'll return it." I'm like, "No, you won't." Like
my
bags and bags of it.
Oh, my life.
Sounds like my pantry.
Yeah, it's like it's everywhere. I'm like, man, you are not going to return that shit.
And it never gets returned. You just get the credit card bill. Yep, because that's the gimmick right there.
You
can try it for free. 7 days you pay for it. Now you got a bunch of crap that doesn't fit.
Exactly. All right, so I'm going to go scoop her. I love you guys. That was fun.
Thank you.
Of course, always.
Pleasure talking to you, Bob.
You too, man. Sorry, like I'm a yapper. I never come in with the intention on completely like over speaking everybody. It's just like if I get on a roll, man, whatever, man. It's like so.
Hennessy got you on that.
I said I need a Bob rant emoji over here for when you come on.
I mean, I'm good for it.
Somebody needs to clip Hennessy making fun of him about that. That was hilarious.
It always comes back. My rants always come from a place of love. You know what I mean? That's like,
absolutely. And I like your insight, so it doesn't bother me. I'll take the insight.
Yeah, and I just try to stick to the law. It's like there's no point in arguing about the facts, and I get why it's interesting to people. It's like that's part of the fun of it. I mean, that's part of the fun of kind of speculating, but like where it gets to be not fun is where people dig in to the point where they're so adamant that something is one way or the other. That's where they lose.
I've said the exact same thing more times than I can count because I don't even know how you can in this case. There's nothing. There's no evidence really presented at all.
Yeah,
just emotions.
What if we get to trial and like we find out that
It's like the contempt hearing.
listen,
What you say,
Bob,
Snoopy?
I was telling everybody last night, like after reading that, I have serious concerns about what McClelland thinks that beyond a reasonable doubt looks like in terms of like if Richard Allen really is guilty, I have a really difficult time with the thought that he thinks maybe his case is really strong like he thought the contempt was, and it's just not. Like I wonder if he even grasps what that means, because he
I'm
seems
with you.
really
I'm with you.
really confident, you know.
I
think
mean,
he
like,
lives in the
I
county.
think from his perspective, you know, because they don't really use Daubert or Fry in Indiana in terms of like that the unspent casing is coming in. You can tell the law enforcement's belief in the strength of that particular piece of evidence is high, and I think that McClelland's confidence in that piece of evidence is echoing law enforcement's confidence in that piece of evidence. And I must say, you know, that like, even though I can sit here and say that it's junk science all day, and they can put an expert on that's going to say that it's junk science all day and it's not reliable. But when you're talking about 12 citizens, it's a powerful piece of evidence. It just
it comes
is.
down to cross.
It
They
does
have to get them to
because like,
destroy
but Dan, like
themselves.
people don't give a shit about experts. Like not the witnesses or the jury just doesn't. I mean, they'll
I
hear them
meant
out. They'll hear them
when the
out. I
guy
mean,
talks.
there's you know, it's been very rare in my career where we've had like Carl Reich, our DNA experts, are like an exception. There's exceptions to the rule where they're unequivocal and that they're so compelling and that they break the science down in such a way that lay people can truly understand it. Because when it gets super science nerdy, people's eyes glaze over.
Oh yeah. Well,
And
Bob, what
Yeah.
I'm referring to is the lawyer literally going up there and making the prosecution's expert disagree with himself on the stand and sound dumb. I feel like that's
but
gonna
it's
happen.
like that's like the
hope.
reality is that any expert that's worth their salt is never going to change their opinion on the stand. You know, I mean, you can attack them in a bunch of different ways. You could back them into corners, but anybody that's reasonably skilled, and I don't know that this Illinois or this Indiana state trooper that did this, you know, that it was the guy whose subjective opinion and analysis is going to be testifying. I don't know that he's that guy, you know, but and then we don't know what these, you know, I have no idea what these confessions are. I mean, the ones that we heard about are obviously, you know, like I don't concern myself like about confessions where they're obviously not related at all to the factual scenario as to what was going on with the girls, but that doesn't even come close to, you know, like what the crime scene, what was happening there. So those I have no problem discounting. I have no idea what was said to his wife and his mother. You know what I mean? Like none of us do. So like he could be relying on these things and thinking that they're very powerful evidence, and they can be. They can be.
And like, I want to be clear. I don't think that when I said that he seems very confident, I mean that it would seem to me that he's confident that like they committed contempt and like will be founding it, like that what he presented at this hearing was compelling enough to have her find them in contempt.
Well, you got to look at the judge here. Is what he presented enough to convince Judge Gohl?
Oh yeah, I'm sure it is. They didn't have to say
But-
anything at that point.
But the thing is that like, so if the standard's the same, if it's beyond a reasonable doubt, then, you know,
That's why we have to be thankful there's a jury.
Yeah, exactly. So she at trial, you know, can agree with everything he says, but I still feel like he just, with normal, regular ass people, I really don't think that he grasps what beyond a reasonable doubt is. I don't think he'll fill in gaps. And I don't, I don't find them particularly compelling. I don't know. I'm very concerned that they're not still getting evidence. I have a theory of kind of what all happened here. And I texted Bob like the other night out of the blue because it hit me all at once. So, you know how Bob always goes on and on about how, like, especially in high profile cases like this, there's no way that a prosecutor is going to let a cop write a probable cause affidavit. It's going to be the prosecutor because they know what thresholds they need to meet because they want to make sure that person doesn't get out on bail. So I was like,
thing doesn't get kicked on a motion to quash.
yeah. So I was like sitting with this new information about what happened at the final, I guess, interrogation with Holeman before he's arrested. And I'm thinking, oh my God. Like, so let's even say that Fig was right about this whole there being, 1.0 and 2.0 versions of the probable cause. And the rumor that goes around is that 1.0 wasn't good enough. The judge kicked it back and then 2.0 appeared. And I was just thinking, like, it would make perfect sense to me if that interrogation went the way that it did. Holeman, on his own accord, without anybody else's input, got frustrated and arrested him. And now here he is. He's sitting in jail. It's been 2 days. They have to release information on why he was arrested and press formal charges. And I think that in that instance, Nick ended up being the one, this is just my theory, but Nick then ended up being the one that wrote the probable cause affidavit that was actually accepted and signed. And I think that the problem with that is that when the defense started attacking that probable cause affidavit and saying that there's lies in it and witness statements were twisted, I think it would give McClelland I think it would increase his blood pressure a little more than if it was just possible that Liggett would get caught in having changed those statements. Does that make sense? Like, if he's the one that wrote it and he changed those statements, it would start sending someone into a spiral where they're doing all kinds of crazy shit and the world starts falling down around them. That, they're getting people booted off of the case. And it just seems like a more reasonable, like, I was trying to figure out why he would be so adamant that these guys not be the ones that he's going up against. And that would make perfect sense to me.
Yeah, me too. I mean,
So
I just I know from experience, like I'm a lawyer. It's like people like non-lawyers giving me pushback on this shit. And of course, every county's different. Every prosecutor's office is different. Typically for high felony cases, like you guys understand, right? That in terms of cops don't make the arrest unless they have approval of a prosecutor who then tells them what they're going to charge. That's never a call by the cops. It's one thing if you've got somebody who goes in and shoplifts, but in cases where it's high felonies and the state knows the threshold that they have to meet and the burden that they have to meet and the facts that they need, they are calling in to whoever's on the hotline on like if they make the arrest and the cops are saying, this is what we got X, Y, and Z. Prosecutors just say, okay, here's what you're going to charge them with. You're going to charge them with boop, 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 boop. It's like the cops aren't making that call ever. Like, you think the cops made the call on what they're going to charge Rick Allen with initially? There's no fucking way. 0% chance of that. That was the prosecutor's office dictating what they were going to be charged with. I promise you. And that's not to say that law enforcement isn't sitting there feeding them the information. They're sitting in the same room. It's a collaborative effort. But the lawyer is writing the legal document. Not a cop.
So it really wouldn't look good for Nick McClelland as a whole if potentially, Liggett's saying, he says, okay, Liggett, like, tell me what the witnesses said so I can add it in here, all 4 of them or 5 of them, whatever it is. And Liggett says, then we had this lady that said that she saw a car, but oh shit, the problem is that, like, it was more or less like a Holeman fucked this whole thing up kind of thing, because now if we let this guy go because he jumped the gun, we'll never see him again. He's gone forever. So I'm not going to put in there that Betsy Blair said she saw a car that looked like her dad's. And the other lady that saw the guy on the road said that he was muddy. He was walking there muddy and looked like he'd been in a fight. So he was probably bloody, right? So I'm going to put that in there too. And
Okay.
that's not going to look good if that's not true.
I want to chime in real quick because we do have two different PCAs. We technically do. And I think, so Fiend was asking, I think it was like last week, like, why don't we have the signed copy of the PCA? Well, the PCA that was out, I don't, so there's the one that, this one.
Let me update you on that though, because I emailed the lady, the lady that I emailed, and I said, I need a copy of the probable cause affidavit. And she emailed me back because I said, this one's not signed and I don't know why it's not signed. I said, so I'm going to need a signed copy. And she said, she finally got back to me. It was like a day later. And she said, this is the response that I received. I could pull it up if you want to know exactly, but she's like, this is the response that I received. And it basically was like, well, that was the one that was redacted and put it out to the public. So they probably just didn't think that it needed to be
the
signed. And I said, but there'd have to be one in the record that is signed. But the craziest part was like the clerk could not pull up the signed copy.
The one from Diener.
She could not find the signed probable cause affidavit for arrest.
But not signed by Diener, right? Is what I'm asking.
By anybody. By Diener, by McClellan, by Liggett, by nobody. It's not signed at all.
They've been doing stuff like that the whole time, it seems.
Okay, so this is the PCA that was released. And this one was signed by McClellan.
No, this is his filing that he included it in.
No, this is the PCA. This one, I'm going to go to that one too. This is
this for the search?
This is the.
Yeah, because he kept including the PCA like in a bunch of filings.
Right. So
no, that's go to the top of this one.
Which one? The one that's
this.
The one
go to the top. Yeah, the signed one.
Yeah, this one.
Well, see, he was signing this motion. He wasn't signing the affidavit.
Right. Like, so, yeah, this is like, he just includes the PCA. Like, so when we first saw the PCA, the first one that popped out when they finally unsealed it, that's the original PCA. So
it's not signed.
Okay, so my whole point to this was, so under this one, okay, so fine, this one's for the subpoena for third-party records. This one is for the search warrant. This one is different than the one I just showed you.
Yeah, they are.
It's written differently. There's different information in here.
Yes.
Yeah, that's because when they, so after they did the arrest, after they did the search, they like got the bullet stuff back. So like that's included in the arrest affidavit. There's certain things and like his certain statements that was made at his second interview is included in the arrest one. So there is more because they have more information because they didn't arrest him till after they searched him, after they spoke to him the second time. So stuff like that is included in the arrest. That's not in the.
They also add like witness statements.
Like which ones?
Like Wesley McWhirter.
Oh yeah.
Like that wasn't in one, it's in the other. So I mean, even like old stuff they add to it and take away from it.
Well, because I think that McClellan's the one that wrote the one for the arrest.
Okay, let me pull that one up. Let me see what that one is.
Because at that point, he would have been sitting with them, right, Bob? Like at that point, he would have been sitting with police.
Absolutely. Because he was already like they had him in custody at that point. You know what I mean? It's like you said, like they clearly arrested him prior to getting the arrest warrant. So at that point, then they called McClellan up. He's like, "All right, I did it. I pulled the trigger on this guy. Get over here. We got to get get the arrest warrant. We're gonna write this thing up." And they did. So.
Right.
Like Sleuthie, I was going to tell you, like, why don't you look through the filings that we know are Nick, like pre Luttrell and pre Diener, So we know
Yeah.
that's like, and just look for similar patterns, writing patterns, like where he uses the same type of words. Like I can tell a Baldwin motion immediately from a Rozzi motion. Like within
Yeah.
the first paragraph, I know who wrote it. I don't have to look at the signature page.
Well, that's what the last one from McClellan we believe was Diener.
Oh, 100%.
Oh yeah, there's no way that was Nick.
No question.
That was well written, right?
Can I jump in and just ask one more quick question? And I'm going to try to relate this to the probable cause as well. But just for the lay person, the general person looking through this probable cause, I can identify a couple of experts you would need just from this probable cause. So, you know, 2 or 3 maybe. Definitely the tool mark expert. But just going back to the fundraiser one more time real quick. So with where they are, with the work they've done, the fundraiser is important because the judge has denied the funds for the experts to continue their work. And if that happens, if they can't continue their work, that's where you get into Rick's Sixth Amendment being violated, because that's where you get to, if they can't continue and they can't forward on, then how can you call it a fair trial? Is that fair?
Yeah, well, it's even more fair if at trial, at actual trial, the state puts on a bunch of experts and the defense doesn't put any on because they didn't have the funds to get them there and to pay them to testify, then it's going to trigger massive Sixth Amendment issues. Massive.
Okay, I got you.
So yeah, your overall concept is 100% correct.
So it is fair to say, like, this money is very critical in Rick Allen getting a fair trial.
100%, man.
Okay.
Like, you just don't want to, like, it sucks to have to like pick and choose. You know, I mean, in a perfect world, like, you know, that's why they always say that wealthy defendants always get the best defense, because they do. Because anybody that you need, like, the amount of experts, like, that's what I was saying. Everybody should go tonight. Forget the first 2 episodes of the OJ, you know, Made in America. Just watch 3 through 5. That trial was unbelievable, but the amount of money that they sunk into experts was unbelievable. I mean, they had the who's who of every single field that you could imagine. You know, it was like in that defense team was insane. Like, if you're like a law nerd like I am, you're seeing like F. Lee Bailey coming in like a relic, you know, and it's like in Johnny Cochran, when you learn about like what he was doing prior to, you know, he was doing civil rights stuff. He's a civil rights lawyer, you know,
Right.
like, so this thing played right into his mitts with the, you know, just with the Rodney King verdicts coming down and just LA on fire and just like LA, like the LAPD and their just overall reputation for beating the shit out of everybody. And then like the whole Furman thing.
Oh, yeah.
You know, oh my God. It was just like, I forgot how much I love that trial until I watched that thing last night. It's just,
I watched it live. I recorded it on my VHS. So that
me
I
too,
could
girl.
watch it
Like that
every day.
I just skipped going. Like, I was in college when it, like, so I just didn't go to class for months. Like, I'd sit there and be like, all right, this is like, I'm learning more from this than I'm going to learn in my my English class. I guarantee it.
I got to see him do the low speed chase or slow speed chase on the 5 freeway. We were standing on the side of the 5 freeway. We ran down there because we knew he was coming by us. So we ran over there and watched him go by. Yeah.
They had like
we didn't have like a cell phone to like record it or anything. So we have nothing cool to like show for it or prove it. Except for
I bet you'll catch yourself. Like, they had like a bit, like probably about a half an hour of one of the episodes was all about the low speed chase. Mm-hmm. Like, it's just like, it was insane.
You can see
like,
me
people,
as a
like, lined like
over there on the side of the
expressways. They like his house, like the street leading up to his house in Brentwood. It was such a, like, the most bizarre thing you'll ever see. And it was so great. That case was just like, it had everything. It had everything. Oh my God. And talk about a trigger warning. Talk about crime scene photos.
Right.
Like, Allison was like, we were watching that. She's like, who is broadcasting? Like, they had the crime scene photos of like Nicole's head basically severed. It was. I was
Horrible
like,
photos.
I was not like. I'm like, I needed a trigger warning before that because like I'm not good with that shit. And I was like, oh my god, I couldn't like. It was stunning to see it. It was like, it was crazy.
They're bad.
They're
And that's why.
unbelievable.
So like when I was on with CJ the other night, and people started kind of giving him crap in his chat too, because he was like, the crime scene photos of the girls, like they're not bad. And people were like, they're not bad, you know. And I'm like, so like the chat, I'm like, they're emotionally terrible,
Right.
because of like who they are.
Girls
They're
were killed.
young
It's like-
girls.
right.
But as a crime scene photo versus, I've looked at a lot of crime scene photos because I originally wanted to be a homicide detective, so I was taking I was looking at all kinds of gory shit, and they're
Further
not.
than Dahmer.
They're
Right,
not
comparatively
they're-
speaking, right?
Right.
They're
Yeah,
just
that's
not
all
as
I meant by that.
gory.
Too, so thank you for
I know
saying
that.
that.
Yeah, I did. I
Yeah,
got you.
and
Oh,
I said the
CJ,
same
dude,
thing
you would
Bob
not
said.
believe how much shit, like, because I was calling, you know, like I get so much shit for calling it the drip because it wasn't the type of leak that came out. And like, am I crazy, or is the shit that Dutch Frank put out? They look like the exact same things that What's Her Face did. Like, are they
So-
different?
What he put out, okay, yes. So hers, she says that she painted him. I believe it's an AI rendition, is what True Crime Design put out. So she'd have to speak on that herself. But what Frank put out was like the photos themselves, but with a filter. So like taking your photo and putting it in like a filter app and changing it, versus she created an entirely separate image and he just filtered the actual photos.
Well, and what was with that, Bob? Like I see how you came to that because I thought it was pretty damn similar. But I just want to say this for everybody. And T, tell me to shut up. Tell me to shut up, T. If I start to go too far over the line. But when I first made before I made my YouTube channel, before I ever made it, the way the algorithm worked, I typed in Delphi Murders and The Unraveling, and Rick Snay came up, and I watched both of them. And Rick Snay did a episode with Chris Todd, and Chris Todd said what his email was. I didn't know who the hell anybody was. I had no idea who these guys were, and so I emailed Chris Todd, and he called me, and I'm just a nobody, and he sent me the True Crime Design picture, and I mean that's pretty damn accurate compared to the crime scene photos. So for everybody that's saying, I want to see the crime scene photos, or for everybody who's saying you're a bastard if you've looked at the crime scene photos, that's pretty damn close, man, what they've put out. But what Frank did, you know, it was the same thing. It's in my understanding, just a different oil pastel overlay, whatever you want to call it. All I was trying to get at was the shock factor. Like, obviously, yes, it's emotional. Like I was emotional when I saw it. It's terrible. I wish we could all just love each other, but unfortunately, that's not the planet we live on. I'm just simply saying there's not this, oh my God, shock factor in the sense of like, I've seen worse things on movies when it comes to the, I need to turn my head. If you didn't know what you were looking at, you know,
dude, watch episode 4 of this thing I keep telling everybody to watch, and you'll see the most horrific crime scene photo I've ever seen. Like Nicole Brown Simpson's head is like nearly severed, dude. It's like I've never seen anything like it. I was like, oh my God. I was
websites dedicated to that crap.
Yep.
Yeah, it's like,
ironically, talking about these crime scene photos, though, I'll say I was having a conversation with my husband about them last night, and he was like, you don't think that they're out there? And I was like, no, I don't think they're out there. I don't think you'll find them. And he was like, you're telling me if I go to Google the crime scene photos that they're not going to pop up? Because I was trying to tell him, like, they're not actually spread. Like, nobody's posted them really, like, not even in like, and I belong to, here, there's another weird thing about me. I belong to a lot of death groups. So like they post all kinds of crazy death. I know.
Well, see, that comes from respect from people. Even the crazy people that look at that crap aren't putting kids up on the internet like that.
So they well, I mean, I don't know if anybody in the group has them or in the groups has them, so I don't know if they could put them up. But what I'm saying is they're not there. I looked on 4chan. I've not seen them there. I don't know anything about the dark web, so I cannot answer to that. I don't even know really how to get there, and I don't want to.
Dark web's not real.
So I'm just saying, like, so my husband sits down last night. He's like, I bet you I can find him. I'm like, okay, go ahead. And so he sits down, starts trying to Google and starts going through different websites that he knows of and stuff. And he goes, all right, yeah, they're not there.
So
like,
listen,
for
even the
whatever reason,
state,
Now the
they
feds
didn't
are
want
at
to
your
put him out.
house.
Well, it's
even
like
the
I
s-
said, like the person who was actually going to be the idiot to put them out would be like banished to like douchebag island, and that's exactly what happened to Frank. Like for whatever crawled up it, like he was so adamant about being relevant in this case. Like watching that, like watching his downward spiral was the saddest thing I've ever
It's
seen.
gross.
Bob,
You know,
we're getting a
so
tweet
gross.
made about us right now, Bob. We're getting a tweet made about us right now. Bob, check these out, by the way. Check that site out. If you did
he's
you put a
still
Zen in?
I can't see
he's
what it
still
is.
on.
Nicotine pics.
Oh,
I've
put a
seen him
Zen in.
recently
What is that?
pop onto random. He's popping in a random
I'll message you.
I'll try those.
lives. But even the state and the contempt thing, even they didn't have anything where, like, they had the crime scene photos, but they didn't have where anybody had like posted it or physically sent it. Like, they didn't have, an email of Mitch sending them directly to Fortson. So that's a problem for me.
Yeah, I like
You know what I mean? If you're trying to prove that he sent them, you don't even have
at this
that.
point, it's like it's moot. It's all moot. Like all of it is moot. Like none of it matters for the trial anymore. And it was like that's the people. Like people just kept confusing. Like Bob says they're no big deal. He doesn't care about the family. I'm like, oh my god. I'm like the concept of anybody leaking any crime scene photos is repugnant, especially like I thought that went without saying. What I was trying to explain to people, like, okay, so they got out there. It's like the concept that they're out there is disgusting. We all agree on that. What the evaluation then becomes is, have they made it out to the public at large to where it now affects the defendant's right to a fair trial? Like that's all I've ever tried to say about it, and people just completely misconstrue what I say about it. And I'm like, I can only say
they just want to repeat it in an offensive way so that people don't go to their opposition.
Right.
That's just virtue
All
signaling.
right, I do have to go for the mall now. I love you guys.
Love you, Bob. Love you, Bob. I was going to say Brad because you're Brad on there still. It's like, love you, Bob.
He is. Bye.
All right. Well, we should wrap it up anyway. We've been on for almost 4 hours. So, and I think CJ, do you still want to go live? Are you going to go live on your channel for a little while and talk, or are you doing that later?
Yeah, I was just gonna go live just for a little bit, just to kind of say my thoughts about what we just read, and I don't want to take up all your time on your channel, but man, I gotta say, thank you first of all for having me on and let me read through that. Thank you for paying the money for it, but what a shit show. I mean, what Michael Osbrook said rings true, and it's that Nick wasted all this time, all these resources, man hours. I mean, these people are getting paid good money, and they couldn't show not one damn time that Andy Baldwin willfully did this.
That's where I'm at. But and Sleuthy did say the actual exhibits, the ones that would matter to what was said, they are under seal. So we don't see these conversations between Cohen and Fortson in their entirety to know, if what they're implying. But my point to that was they didn't, if they're truly implying that Baldwin was in contact directly with Fortson, or even sending crime scene images and discovery to Westerman, they didn't even try to attempt to prove that with anybody on the stand. They just said it, and then everybody was just supposed to go, oh, okay, I guess that's the truth then. But they never went into any questioning or anything about any of it to show there was any direct communication.
Right. And not only that, but again, it's concerning to me that, and T, you've been on YouTube a lot longer than I have, but T, would it be fair that we'd pay some money to get an inside scoop if we could bring it to our YouTube channel and be the only one that had it? I mean, it is concerning when you've got these creators out there like Fig Solves who absolutely had information that no one else did. How the hell did that happen?
It's hard for me because I never watched the video that was actually being talked about, the one that where where he talks about that there's a bullet in this other PCA and that stuff. I never saw that video, so I have no context around like how he got the information at the time. I also do know that there, I mean, not only are they claiming Nick, but like we know that Holeman was talking to multiple people. I mean, if we're just going to go with screenshots and those can now just become evidence, I mean, we're going to say, hey, we have plenty of screenshots of Holeman talking to multiple people on the internet. But then are we going to go with that there was no gag order, there was no protective order, so it doesn't matter? I don't know.
Well, there's a screenshot out there, and I think the Unraveling has it on their Twitter, but there's a screenshot. Actually, there's multiple screenshots on the Unraveling's Twitter of Nick McClelland. It's his damn Facebook talking to somebody. I mean, I guess my point is this. Obviously, this is a high-profile trial. Why even give anyone an inch to say you messed up? You're doing things why even give them an inch? And he gave them feet, in my opinion. And these screenshots that, again, they are out there. What is he doing, man? What are you doing? Why are you even giving anybody an inch? You want to talk about doing a disservice to the families? This is my opinion. That contempt hearing was a disservice to the families. It's a damn waste of time. And if you're out there talking to YouTube creators and doing the same shit that you're accusing the defense of doing, you are doing a disservice to the families of all involved, including Richard Allen.
I don't disagree with you in the slightest. I think we're on the same page with that. Right now we're doing a disservice to Richard Allen, but we're doing a disservice to the girls. And I say this a lot, and I know that people probably get tired of it. And I think this is also probably where people don't understand where Bob is coming from, is because the trials, human beings think about a trial and they think about that they're getting justice for the victims, and that's what the trial is for. And I try to make people understand the trial is for Richard Allen. It's Richard Allen's trial. It's the state versus Richard Allen. It's at the end of it, there can be said justice for the victims. But right now, it is about Richard Allen. Whether you think he's innocent, whether you think he's guilty, that's what the trial is.
Right.
It's for them to prove beyond a reasonable doubt that he's the one who did this.
Right.
And then for the defense team to protect his constitutional rights as an American citizen. I mean, it's not.
And that's the only reason, T, I wanted to plug and I'm sorry, T, I'm not trying to step on anybody's toes, but I just wanted to plug the fundraiser one more time because, a lot of people have been told this fundraiser is so important in order to get Rick a fair trial. And, I think we explained it well on here, the experts need to continue to do their work. And I mean, who the hell is going to work if they don't get paid, except for, I guess, in this case, Rozzi, but whichever one of them it is.
Rozzi.
Yeah, but I mean, we're not asking for much here, guys. We're not asking for much. I've talked about the little bit of a selfishness piece. We all want to know what happened, but damn, man, it's important. Let's send the families away with them having the closure they need. Exactly. And when I say families, look, let's send a woman away from that trial knowing damn good and well what happened. Let Kathy feel comfortable with whatever verdict we end up coming up with. Let's not have a situation where we're all making YouTube videos for the next 3 years because none of us know. I God forbid we see that. That would really break my heart. And I think that that's all the fundraiser is getting at. Let's have a trial play out where we have the best opportunity to finally know. And then let's put a wrap on this thing, or a bow on this thing.
When it comes to the fundraiser, people like to, the opposition likes to say, like, you're donating to a child killer. And it's like, not everybody believes that. Not everybody believes that he's a child killer. Number two, a lot of people believe that he's not receiving a fair trial. And whether they're on the fence, whether they think he's guilty, whether they think he's innocent, that there's no reason. So people are donating to support their own constitutional rights. And it's not necessarily about Richard Allen. It's about making sure that at the end of all of this, that we all absolutely get to know the truth. and I'll echo Bob on, like, I am so happy that we have a trial around the corner, because no matter the outcome, there will be certain things that will no longer be able to be rumored and made up and put out on the internet with the mass amount of people believing it.
Right.
You know what I'm saying? Like, that's for me. Like, I don't want to spend my time just debunking other people and showing that they're wrong, because I think that that's just it's a very dark rabbit hole to go down, because you'll stay there forever, because you'll never ever get out. You know, but then sometimes you don't have a choice. So I think that the trial is the best debunker of all. It's like, no, you're wrong. They showed the evidence. This is what it says.
Right.
You know, this is exactly what, what he said in this interview. This is exactly how he said it in this interview, and we get to hear the tapes. So,
Right.
But I have to ask you before we wrap this up, have you heard, is there going to be a different fundraiser if it has to do with the Stripe thing? Or in the updated version of the Stripe thing, can they do it to pay the defense attorneys? Because somebody mentioned this in the comments, where like the updated rules are they can pay for a defense team, but they can't pay for other things outside of that, or something like that.
So the only information I have, and Michael's still in here. So Michael, please say in the chat if I'm going off the rails here. The only information I have is, because I'm not an insider by any means, the Stripe payment processor has shut the account down. And so this fundraiser, the Pay to It fundraiser, that is over. That is done. If people are checking back on there tomorrow or Tuesday, that's over. That's from what I understand. Now, as far as setting something else up, I don't see why that would be a problem. We were about $4,800 off from the goal. Pay it to. I said it wrong. It was pay it to, not pay to it. But either way, I don't see why it would be a problem. I don't see an issue from a legal sense. But Angela and I are going to talk. We were talking about setting something up, because I mean we don't have a whole long way to go. Like I said, we're only 4,800 out.
Okay.
But we're going to talk about, I'm hoping within the next couple of days I can bring something out there, that we can use. I'm out of my realm here, so I gotta get help from people who have done this kind of thing before. But
have you talked with Allie from Unsolved Crimes?
I haven't. I saw that she was in here, and Allie, if you're in here, shoot me an email. My email is literally just my channel name at gmail.com, case closed with CJ at gmail.com. But if we can figure something out here, I mean, hell, 4,800 is nothing, man. We can knock that out. The issue, of course, is just that we just don't have a way to do it right now. So I'm hoping. And T, can I just mention one more thing?
Absolutely. Whatever you want.
I would like to put something together for Kathy. I haven't seen anybody really do that. I'm not taking away from the family of Abby and Libby. They deserve all of this as well. It's just that I'm just coming at it from an angle of I've seen a lot of people do things for them. I haven't seen anybody do anything for Kathy. A travel agent in Indiana actually just reached out to me that said they could put a very reasonable package, at a good discount together for her. I don't want to do it before the trial. I want her to be able to focus on the trial and take all that in. But after the trial, I would like to try to do something for Kathy. So be on the lookout for that.
Okay. I think that's nice. Regardless of the outcome of this, I mean, and I know that there is a handful of people that, think that she may have some type of knowledge or whatnot. And I get it. I mean, I understand the speculation behind it, but at the end of this, I mean, she'll, if he's found guilty, she's another victim of what Richard Allen has done.
I don't get how people don't empathize with those, like Dennis Rader's wife and all that stuff. Like, I couldn't imagine.
Yeah, you made a great point there, T. If he's done this, I mean, take away if he hasn't done it. My God, what a shit hand you got dealt. But if he has done it, this poor woman, you know, that's all I'm looking. I'm trying to look at this from a human aspect. I'm trying to have a heart for everybody. And I want to just have a day to have a heart for her. And I don't think if people want to call me a bastard for that, it's okay. I got broad shoulders.
I don't think having a heart for people in general is a bad thing. So if that's kind of dumb on their part, but somebody asked something in here I wanted to address really quick about the fundraiser itself, that like asking about like what it's for. So I believe that the best source of that information for, instead of me repeating it, would be to watch Hennessy talk about it on Unsolved Crimes Uncovered. And I think that they dual streamed it on Bob's channel too, because he gives the most clear answers. For my understanding is that it is going to go directly to pay the experts that they have already, Brad and Andy have already employed. They've already signed on and have given all their initial, thoughts on things, but they still have to go through like the process of all the things to do to testify to be an expert witness. And then they have to be able to write all that out and give it to like the prosecutor, and then they have to get paid to testify. So there's still more time, and that it's the fund is to pay them so that Baldwin and Rozzi aren't just paying them out of pocket. And I can guarantee you they have already paid them out of pocket. I mean, that's my own personal opinion, but they're not just going, okay, well, too bad we don't have any defense attorneys. We don't have any experts for the defense. They're still working with them. And hopefully, like Bob said, they have submitted the supplementals and the requests for, reconsideration to be paid. So hopefully some of those things are happening. We just don't get to see them because they're ex parte and we're not privy to those filings. So hopefully there's something happening behind the scenes where they will get paid. But I'm telling you right now, the amount of money that, well, even when it was at $25,000, it's just not enough to pay expert witnesses. It's just not.
Right. Especially when you're talking what 5 or 6. I mean, we need a mental health, we need a tool mark, we need maybe a confession expert, blood spatter, DNA, geofencing, right? There's 6,
And they
Right.
have to pay them to sit in the trial the whole time and observe the trial and give remarks to the defense and all that stuff too.
Yeah.
Right. So I think that I hope that there's another way for them to continue to collect donations. I'm sure that with the amount of people that are intelligent enough to know that about that kind of, that's not me. That's not my forte. I mean, shoot, I'm struggling raising money for my daughter's gymnastics trip. So don't ask me because I'm not the one. But I think that they'll come up with a new way of getting it. Just know when you guys are doing the super chats, and I know that this has mostly been done like on CJ's, that we as YouTube creators, we don't get paid until the end of the following month. So just know, like, that's why and I know CJ has said this on his panels, that depending on where that payment falls in the process of whether they still need the money or not, like what he wants to do with that or donate it to, we want anything that you give us in a super chat today, we won't see until the end of May.
Yeah.
So just know that.
And they take 30% from that too.
And they take 30%. So and as great as it is that everybody's donating, and I mean, I think it's a great thing to do. I just know that hopefully they figure out a new way to get the donation set up, which it'll be a lesser fee because YouTube takes an immense amount. That's why for me personally, like as a creator, I keep my link tree up there. It's got like Venmo, it's got PayPal, it's got my tip jar, it's got buy me a coffee, any way for anybody to support the channel financially that doesn't take the 30%. So that's just another thing to keep in mind. Like I said, I just don't want people to like freak out and CJ's like, I know I haven't given him this money yet because he doesn't have it. We don't have the money. Like it doesn't just come directly to our bank account. That's what I want to make sure you guys know.
Yeah. Yep. Absolutely. Well, thank you, T. I'm going to head out. I appreciate you, and I'll catch you next
Do you already
time.
have your stream set up? Because I can send people to it.
No, let me
If you want to do that, I can make the portal.
Okay, perfect. I appreciate that. Yeah, let me do that real quick.
Okay.
And if you want me to jump in over there, just send me a link. Thank you, T.
Okay.
It was a pleasure being
No,
on here.
Dan, thank you so much for 2 days in a row. I mean, I can't thank you enough, and everybody who came up, and CJ, and I don't know where Sleuthie took off to.
Thanks for giving us a Sunday, you guys, on the chat.
I know. Thanks for
Okay,
hanging out
what
with
do
us.
I have to do, T? I got it created. Do I have to do anything?
Let me just double check. You have it on the back end where people can be sent to your channel. I think it's an automatic yes, but I'm going to check it right now to see if I can send people to you.
Okay.
But otherwise, it's under like the tab. It'll say like redirect, like allow other people to redirect to me. Case. Let's see. Case closed. No. So here, let me show you. Let me see if I can find out where it is. And then I'll do all my thank yous. And I know the people were donating here and such. So under, it's under customization. No, maybe not. Settings. Let me see. I'm looking to see where it is. It's on one of these. Okay, so under the settings tab in your studio.
Okay.
Go to community.
Okay.
And then scroll down and it'll say live redirects. It says like, and then I have mine click like all channels can redirect to my content.
No, I don't see that one on my T. It's okay. I'm so bad with technology. We'll just get it rocking and rolling, and I'll figure it out.
Okay, I'll just put the link in the chat, then people can just head over there.
Perfect. Thank you, T.
You're welcome. Thank you guys very much.
Yep, I'll catch you next time.
All right, sounds good. Thank you, thank you, thank you.
Yep.
Okay, you guys, let me take a look at this, and then if one of the mods, would you guys mind grabbing the link for CJ's live, and then we can put it in here. But I just want to say thank you guys. I mean, I don't typically do things on the weekends, but I thought that this was something that would be enjoyable over the weekend because it's not overly serious and it's something that we kind of already knew about, but at least it would be beneficial to read through. And I mean, the amount of people who came on to help, if you guys are still here, I owe you a debt of gratitude. Thank you so very much. And once again, I have to give the really big thank you to my friend who was very close to the courthouse and was able to go pick these transcripts up for us and get them scanned in. So we got them so quickly. I just know I am deeply indebted to you, and I owe you all my gratitude. I'm going to tell you guys. So Gretel, Ellen, TT, thank you guys for joining the memberships. Wood Chipper, for money for the cuss jar. Well, good thing I don't have one of those. I would definitely be broke, and whoever got that got access to the cuss jar would be rich. Dan, thank you. Slap the like as a thank you to Criminality for hosting the panel and maintaining entertainment and neutrality simultaneously. Well, that's very gracious of you. Thank you. Lead with love, $10 to the crowd justice. I will make sure that once this is all figured out, I will figure out how to get this your $20 donation to them. I promise you that. And Peggy, thank you so much for the super sticker. Like I said, I know that you guys always have 1,000 other places that you guys could be, and you choose to spend your time here hanging out with me. It is extremely humbling to know that you guys care at all about what I have to say. So thank you from the bottom of my heart. Number one, just for your support, just for being here. Even if you're not one of the ones that talk and chat and you just listen, still, I cannot thank you enough for just supporting me. And I should be back tomorrow. If there's nothing happening in Delphi, I do have a Karen Reed live planned with all the stuff pulled for it. So if there's no big drops in Delphi, then I will probably do a Karen Reed live tomorrow as we head into the Karen Reed trial starting either tomorrow afternoon or Tuesday. So go enjoy the rest of your Sunday. Hang out at CJ's if you want to talk some more Delphi. And I will see you guys tomorrow. Have a good one.
Do you dare to fall on it stops, no one knows. We're going down. We're going Do you dare to follow me down? Head into the unknown.